And Madam Hearing Examiner, I have a question. I don't think it has to be on the record. I just want to confirm something when you have a moment.
Okay, we are being live streamed. Thank you, Miss Anna. Go ahead, Mr. Haverly.
Yes, Madam Hearing Examiner, I would just like to confirm how you would like me to lodge objections. I was, I thought I was following your protocol yesterday from your Zoom order to say objection, announce who I was, and wait for you to recognize me. But it seemed like maybe there was a delay, and I just want to make sure that I'm following the protocol you would like me to follow when making objections.
That's fine, Mr. Haverly. I think that, I think most of the parties are not as formal as what you've just announced. I think it would be great if parties actually did it that way. But I think normally what they just do is objection, and then we got to figure out who it is, and usually it's the correct attorney, and then they launch into their and then they launch into what their objection's about. But either way will work for me. But yes, I appreciate your formality in wanting to do it the correct way.
Madam Hearing Examiner, you're running this show. I want to do whatever it is that makes your life easier.
I
Well,
appreciate that. Thank
a,
you.
a comment from opposing counsel. Mr. Haverly
Who
was trained.
breaks in and doesn't,
Yeah,
doesn't wait for you to finish, and you
Mr.
know.
Haverly was trained at Harvard, and it's showing through.
Mr. Haverly, let me also just thank you for your question, and kind of build on that. This is the end of a long week. It's the end of a long process since this case was first filed. We have several more days and weeks and perhaps months to go of more work. So just to reiterate to everyone, let's proceed calmly and methodically today and for the rest of these hearings. I think it'll make everyone's life easier. Also, hearing examiner Hurst and I were discussing the benefits of just clean examination and particularly cross-examination. So this does touch on what Mr. Haverly just asked, but when an objection is raised, please, responding party, have thoughts about the legal basis for opposing that objection. That makes life easier. And there is, I think, also a tendency to comment or be conversational with the witness, but just if we could keep it clean with question and answer, I think that'll also be beneficial for Mr. Lee. It'll help the examination and getting the testimony into the record. So thank you, Mr. Haverly, for raising that. It's always good to just take a step back and think about how we're proceeding. And hearing examiner Hurst and I really appreciate that. We're here to preserve the integrity and efficiency of the hearing and this whole process. So everyone's attention and is very much appreciated. Thank you, Mr. Haverly.
Thank you, hearing examiner Schaefer. I think those are very wise instructions for all of us. We are people, but we're here for a purpose. And so I think that's good. We have approximately 7 minutes before we resume our hearing, and I believe, if my note was correct, that from the closing of yesterday, we 74 minutes would be for Mr. Yar, but then there's been an agreement due to commitment with Dr. Erickson. We are going to take him out of order as an accommodation that the parties have agreed to. So, joint applicants, if you'd like to get your witness ready, that would be good. Mr. Alvidrez, you have your hand up.
I do, Your Honor, and Dr. Erickson is here. My hand is up for a different reason. Last
Okay.
evening, we received copies of some revised NE exhibits, and I know they were sent to the hearing examiners as well. One of which was NE Exhibit 2, which is the direct testimony of Mr. George, who was the subject of a motion in limine. And it appeared to us that the testimony has not been modified significantly and doesn't match what the order is. I mean, he was specifically ruled as not an expert, and that his testimony was limited to proceedings, only those proceedings in which he has participated. And my understanding is the only proceeding that he actually participated in is the proceeding before the New Orleans City Council with respect to one of the transactions involving the Delta utilities. And so we still have, numerous opinions about other matters and what the standards are in New Mexico and what the corporate responsibilities are and so on and so on. And Mr. George, I believe, will be appearing on Monday, so we've got to prepare for cross-examination. So some guidance on his testimony would be helpful.
All right, sir.
We did not get the testimony is changed, but it did not appear to be interlineated, so we don't know what all the changes are.
Okay. Mr. Lee, how are we doing this morning?
Good, how are you?
I'm doing well, thank you.
Who has the next witness, counsel, if you mind telling me for NMGC?
Mr. Lee, this is Rick Alvidrez on behalf of the joint applicants in this capacity, and we'll be calling our next witness.
Thank you.
The hearing examiner advises.
And Mr. Lee, I'll be the NMGC attorney in the room with Mr. Alvidrez.
Thank you.
And the witness.
Very well. Mr. Lee, if you are ready, sir.
I'm ready, Judge.
All right. Good morning. We are back on the record on day 5 of our hearing in case number 24-00266. This is in the matter of the joint application for approval to acquire New Mexico Gas Company by Saturn Utilities Holdco. Along with me today is my co-hearing examiner, Patrick Schaefer, along with Chairman Aguilara, and Commissioner O'Connell. Additionally, Mr. Lee, our court reporter, if you need anything to deal with the transcript, you need to deal with him directly. Could I go ahead and get appearances for our record this morning? Beginning with staff. Ms. Lang, Mr.
morning.
Friedman, there he is.
Good morning, everyone. This is Ryan Friedman. On behalf of staff, I'm here with co-counsel Katie Lang and Nicholas Rossi.
Very well. Ms. Nanasi.
Good morning, everyone. Marian Lanassi on behalf of New Energy Economy.
Thank you. Mr. Freeman.
Morning, everyone. Jelani Freeman on behalf of the federal executive agencies.
Thank you. Mr. DeSalen.
Good morning, Madam Hearing Examiner, colleagues. This is Charles DeSalen representing Coalition for Clean Affordable Energy, and I believe Ms. Carol Lynch is also with us representing Coalition for Clean Affordable Energy as well.
Okay. Ms. Beatles?
Hearing examiner, sorry.
Go ahead, Ms. Lynch.
I'm here and I'm also representing Prosperity Works.
Thank you. Ms. Beatles?
Good morning, Madam Hearing Examiner Hurst, Hearing Examiner Schaefer, Commissioner Aguilera and colleagues, Sydney Beatles for Western Resource Advocates.
Thank you. Mr. Gould?
Good morning, Madam Hearing Examiner and Mr. Schaefer, commissioners and colleagues. Peter Gould for Anna Maria. I'm joined by my colleague, co-counsel Joe Yar. I will be handling the cross-examination of Dr. Erickson, and he will be continuing the cross-examination of Ryan Schell.
Thank you. Mr. Haverly?
Thank you, Madam Hearing Examiner. Brian Haverly, Tom Domi, and Juliana Hopper on behalf of Amera, Tico, and New Mexico Gas Company. With me is Nicole Strausser, who is also the General Counsel of New Mexico Gas Company. Appreciate it.
Thank you. Mr. Alvidrez?
Yes, good Friday morning, hearing examiners and commissioners and colleagues. I'm appearing on behalf of the BCP applicants in this case, and with me this morning is Dana Hardy, also representing the BCP applicants.
Thank you very much. I believe I've gotten everyone that I
Madam
see on
Hearing
the participant.
Examiner, this is Brian Harris. Good morning
Oh.
to colleagues and the hearing examiners. This is Brian Harris appearing on behalf of the New Mexico Attorney General and the Department of Justice.
Thank you, sir. I wonder why you're not showing up on my list.
It's in very dark shadow, Brian.
Oh, there you are. Okay. Yep.
I'm still
Okay.
getting used to this technology, Madam Hearing Examiner.
It it continues, Mr. Harris. We had a couple of procedural issues before we begin. And joint applicant's attorney, Mr. Alvidros, is asking some questions about some potential exhibits. I think that you emailed Ms. Nanasi? Is that correct?
Okay, I'm sorry, I didn't understand what you just said, but I emailed a number of exhibits yesterday, and one of them was a revised revised exhibit, New Energy Economy 2. I am happy to discuss this. Did you want to address the cross-examination of Dr. Erickson first, given his time crunch, and then we could talk about it after that?
Just generally, you believe what you emailed is in compliance with the order on your motion in limine.
My understanding of it, yes,
Okay.
I can discuss that with you. I wouldn't have done it that way. And also, I thought that it's different. Corrections are different than when you respond to a motion in limine about something. But I'm happy to give another copy of it with red line
Okay.
as well.
Okay, I just wanted your general response to that.
But I might
So
be
I think you've given
mistaken.
that.
I might be mistaken. I thought my reading of it was correct, but it
Okay.
might not have been. So I'm happy to do what you want me to do.
Okay, thank you.
Thank you.
And Mr. Gould, you also want to discuss something to do with an exhibit? Is that correct?
Muted.
Muted. Sorry about that. We wanted to ask for the admission of NMR Exhibit 45, but we can do it after Dr. Erickson's cross if we're time limited on his appearance.
Okay,
Thank
very
you.
well. Do we have any other procedural issues? Okay, not hearing any. Yes, let's go ahead with Dr. Erickson. Mr. Alvidros, you have a witness.
Yes, Your Honor. We call Dr. Christopher A. Erickson to the stand and ask that he be sworn.
Very well. Mr. Lee, would you please swear Dr. Erickson?
Dr. Erickson, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
And good morning, Dr. Erickson. Can you please state your name for the record?
Christopher A. Erickson,
And Dr. Erickson, where are you employed?
New Mexico State University.
And in what capacity are you appearing in this proceeding?
I'm appearing here as a private consultant.
And Dr. Erickson, did you prepare revised application, direct testimony, and exhibits dated July 3, 2025 in this case?
I did.
And can you confirm that we've marked that as joint applicant exhibit 14?
I can.
And do you have any changes or corrections to your testimony?
I do not.
And Dr. Erickson, if you were asked the questions that appear in that testimony today, would your answers be the same?
They would be the same.
And is that testimony true and correct to the best of your knowledge and belief?
It is.
And does it include any attachments or exhibits?
It does. Includes two attachments. One is a report that was prepared for me as part of my testimony, and then the second is my via.
Your Honor, we would move the admission of Joint Applicant Exhibit 14.
Any objection to what's been identified as joint applicant exhibit number 14, the revised application direct testimony of Dr. Erickson as affirmed by him here today? Hearing no objection, joint exhibit 14 is admitted.
And moving on,
Mr.
Dr.
Alvidrez?
Oh, thank you, Your Honor. So moving on, Dr. Erickson, did you prepare revised application rebuttal?
Mr. Alvidrez, I cannot hear you at all.
Lost your audio.
Am I back?
Yes.
Okay, apologize, technical glitch. Let me start over, if that's all right. Dr. Erickson, did you prepare revised application rebuttal testimony dated October 10, 2025 that we marked as Joint Applicant Exhibit 15?
I did.
And Dr. Erickson, do you have any changes or corrections to that testimony?
I do not.
And if you were asked questions that appear in that testimony today, would your answers be the same today?
They would be the same.
And is this testimony true and correct to the best of your knowledge and belief?
It is.
And does this testimony include any attachments or exhibits?
No.
Your Honor, we've moved the admission of Joint Applicant Exhibit 15, the rebuttal testimony of Dr. Erickson.
It's not critical, but
Any objection to what has been identified as joint applicant exhibit 15, the revised application rebuttal testimony of Dr. Erickson as affirmed by him here today? Hearing no objection, exhibit 15 is admitted. Mr. Alvidrez?
Yes, Your Honor. With that, we will pass Dr. Erickson for cross-examination.
Thank you. Mr. Gould, I believe that in the cross-examination order, you are first and that you have reserved 15 minutes for Dr. Erickson.
yes, ma'am.
Go ahead, sir.
Good morning, Dr. Erickson.
Good morning.
My name is Peter Gould. I am the counsel for the New Mexico Affordable Reliable Energy Alliance, commonly referred to in these proceedings as NM Area. And welcome.
Thank you.
I think this is your first time at the commission, correct?
I testified in the 90s on issues of title insurance. I believe that was part of the PRC at that time, but I don't think it is anymore.
Well, welcome to our proceeding. Would you turn to your revised, I think it's called revised application direct testimony and exhibits filed in this matter on July 3rd, 2025?
Yes.
Would you look at page 5 of that testimony, please?
I'm on page 5.
Okay. There is a line 1, it says direct effects. Do you see
Yes,
that? Would you
do.
just read that to yourself to refresh your recollection?
Yeah. Done it.
Before we start my questioning on that, would you explain what is meant by the concept of FTE, Frank Tom Echo?
That's full-time equivalent jobs, and that is typically taken to be a 40-hour week of a full-time employee. And so if you talk about FTEs, you're talking about full-time jobs. Those jobs might be filled by more than one person. For example, job sharing or two part-time people would fill an FTE rather than only one person filling it. And so it's used because it becomes a kind of a standardized unit of labor.
In some places in your testimony, you refer to 21 direct jobs, and other places you refer to FTEs, and they're slightly different numbers. Can you
Yes.
explain why?
Because FTEs are full-time equivalent, and there's 20 full-time equivalent jobs, but our model estimates there'll actually be 21 people employed, that there'll be two part-time people, or it could be three part-time people, but anyhow, that those FTEs will be divided up among 21 people rather than be all the 20 people. Implan does that for us, and it does it based on industry averages. And it says that the industry average is that some of these jobs will be part-time.
Okay. And in line 4 of what I asked you to look at, you quote a figure of $2,361,960. Did I read that correctly?
Yes.
And you said, based on our analysis, the total labor income for these direct jobs, and you're talking about 21 jobs, is projected to be that 2.36
Right.
million.
And of course, it's clear, just to be clear, the concept of labor income includes both the wages and salaries paid to the employees, but also payroll taxes, Social Security contributions, those sorts of things also.
Well, you're anticipating my next question. If you could, thank you. If you could go to page 3 of that direct testimony and look at the table that is JA table CAE1, open parens, revised application, close parens.
Right. I'm looking at it.
At the top of that, you have the naming of the columns, and the second column is labeled 20 new jobs.
Yes.
Okay. I am confused because the labor income there is listed at 3.6 million roughly. What is the difference between your 3.6 number and the number I just quoted, the 2.36 number on the other page?
Yeah.
Hold on just a second. Dr. Erickson, you got to wait until the question is finished.
Right.
The court reporter can't take both people at the same time, sir.
My apologies, Madam Commissioner, Madam Examiner.
My question is done, so if you would please answer. Thank you.
Go ahead, sir.
So they're projected to, yeah. So this may be a mistake. There are two. The 3.6 million is how much is being paid by the is how much BCP says that they'll be paying those employees. That's actually higher than what would normally be paid in this market. And the 2.3 million is the number that is actually projected by the model. I will mention that in our later analysis, we used the number that was given to us by BCP.
Which is the 3.6 million.
Which is the 3.6.
And related question, is it your understanding that 3.6 million will be paid, those jobs represented by that number will be new hires at New Mexico Gas Company?
Yes.
And is it your assumption, if you know, as part of your analysis, whether those jobs will be paid for by the BCP applicants or by New Mexico Gas Company?
Can you repeat the question, please?
Yeah, maybe if I tell you where I'm going, what I'm trying to find out is what is the cost to NMGC of hiring 20 new jobs? I'm not interested in the cost to BCP in this question. I want to know the cost to their affiliate, their proposed affiliate, New Mexico Gas Company.
Yeah, I'm not sure what that number is. My understanding is that that'll be done by a joint service agreement of some sort, and that New Mexico Natural Gas will be paying some sort of service fee. But I have no knowledge of the details of that agreement.
Okay, perhaps that's a better question for the president of New Mexico Gas, Ryan Shell. Would that be a fair statement?
I think that's a fair statement.
Okay, that's what I wanted to clear up. My second line of questioning is about the changes that occurred between the initial application and this new job figure, and very, very high level. When you were initially hired and you initially did your analysis, you came up with, and I'm looking at your original direct testimony on page 2. You had a table that had direct jobs and you had a range, 64 new FTEs or 52. And in that range, those were the new hires. Do you recall that testimony?
I do.
One moment. Mr. Gould, do you have an exhibit to which we can refer Dr. Erickson so that he can look at his prior testimony?
We included all of the initial application. And Rick, let me just ask my second question, and we may not need to go deep into. Okay.
Okay.
You recall that
I recall
that
the numbers were different previously. Yes.
Okay. My real question is, when were you informed that you needed to adjust your FTE numbers in your initial testimony and adjust them downward to what you have in your revised testimony?
Well, I actually don't remember the exact date. It was relatively shortly after we had submitted the original testimony, but I couldn't tell you the exact date.
Would the month of March be consistent with your memory, or is it earlier? You don't know?
I cannot give you an answer to that. I don't recall exactly when I was told.
Okay. And these are my last couple of questions. What were you told? What were the reasons that you were told for revising your numbers of FTEs?
I was told that they were not going to move as much of the back office operations to New Mexico as was originally planned.
Okay. What kind of detail were you given about that change?
Very little. We really only asked for the numbers.
Okay. Dr. Erickson, thank you very much. Those are all my questions, Madam Hearing Examiner.
Thank you, Mr. Gould.
If I need to give Rick the exhibit number, I can do that, but I don't think he needs it at this point.
No, thank you, Mr. Gould. We're
okay. Okay. Thank you again. And Madam Hearing Examiner, I'm going to very briefly, most of the day I'm going to be off, but I'd like to stay linked in. So I will be muted, but thank you.
Thank you. Ms. Nanasi, I don't believe you had any questions for Dr. Erickson.
No, I didn't reserve any. Thank you.
Thank you. And Ms. Beatles, I do not believe that WRA had any questions for Dr. Erickson. Is that correct?
That's correct. Thank you.
Thank you. And it looks like CCAE had reserved 30 minutes for Dr. Erickson. Is that correct, Ms. Lynch?
Yes, Madam Hearing Examiner, that is correct. I will be conducting the cross-examination of Dr. Erickson. Thank you.
Thank you. Go ahead, Mr. DeSalin.
Thank you. Good morning, Dr. Erickson.
Morning.
My name is Charles DeSalin, and I am representing Coalition for Clean Affordable Energy in this matter. And just to let you know, I'll be referring mostly to your report, which is entitled Economic Impact on New Mexico of Acquisition of New Mexico Gas Company by Bernhard Capital Partners. And that is Joint Applicants Exhibit 14, and it's also marked as JA Exhibit CAE-1. And I presume you have that handy.
I do have it.
Okay. Just just to start out, at the beginning of the report, there's a list of the authors there, and that's on well, it's labeled at the top of the page on the right-hand side as page 2 of 24. And it lists 3 authors there. Do you see that?
Yes, I'm looking at that page.
Okay. And it lists you and a Dr. Winningham and a Dr. Lucinda Vargas. Is that correct?
That's correct.
And who is the principal author of this report?
We wrote the report together, but I was fully involved in every aspect of writing the report. Dr. Winningham is the person who actually ran the software program and provided the tables. He and I did much of the writing also, and then Dr. Vargas is proofread the report, and if she had given us any substantial changes, we of course would have paid attention to her comments, but I don't recall her giving any substantial changes. She did find some typos and some, suggested some small changes in the writing.
Okay. And then you explain in the report that you used the IMPLAN, that's capital IMPLAN, in all caps, economic model.
That's correct.
Now, I know you inputted some population figures for various counties in New Mexico into the report, or into the model.
I don't think that's correct. I don't think we inputted population. The population numbers for New Mexico are already included in the software package.
Okay. Were there any other inputs that were specific to New Mexico other than population?
Well, a good deal of inputs. The model that we use is fully specialized to New Mexico county by county. And it looks at the spending patterns in each county within each industry, and then uses what we refer to as an input-output model to estimate the impact of that spending throughout the county. It takes into account the flow between counties, and it takes account the flow.
I'm sorry, doctor. It takes into account the
flow between counties in New Mexico and the flow from counties in New Mexico to the rest of the nation, to other states. And then we take those results and aggregate them. The model does that for us, and aggregate them to give you an estimate for all of New Mexico. For example, there's a slightly different estimate for the impact by virtue of the fact that the jobs are expected to be located in Bernalillo County, as opposed to one of the other counties in New Mexico.
Okay. Then let's move on to page 4 of your report.
Mr. DeSalen,
yes.
I do want to make clear that we did input some data, which is the data we received about the particular project we're looking at here.
Okay, thank you. So now if we could move on to page 4 of your report, and I mean page 4 of your report as it's labeled in the lower right-hand side, which is also marked as page 7 of 24 at the top right.
Yes, I'm looking at that page.
Okay. And there you talk about methodology, and you describe the difference among direct impacts, indirect impacts, and induced impacts. You see that?
Yes.
And could you, I'm a little unclear, could you just explain in your own words what you mean by induced impacts?
Induced impacts are result from the spending by households who receive wages and also other income potentially from the operations of from the operations arising from these 20 full-time equivalent jobs that are expected to be located to New Mexico. So if you think about a household receiving wages and salaries, they then spend that wages and salaries, and that then has a knock-on effect because they're buying goods and services, and that's referred to that as the induced effect.
Okay, thank you. And now let's move on to page 11 of your report, which is page 14 of 24, which is where you talk about jobs.
Yes.
Okay, you there?
Yes, I am.
Okay, and now first of all, you refer to the jobs as back office jobs. What does that mean?
Well, of course, these are accounting, payroll, those kind of jobs. Some IT, I think, is also going to be relocated, and so finance, and so we would view those as jobs that are being done in the office and probably in the area that's not public facing. So that's referred to as back office jobs.
I see. Okay. So is that like a term of art?
It is a term that I've heard used commonly, and I've been a faculty in a business college for many years, and I've heard it used in the hallways by other faculty, and I also think it was actually the term that BCP used when they told us those numbers, what those people are going to do.
Okay. Now your report says that the new jobs arise from BCP's relocation of employees to New Mexico. Do you
That's
see
correct.
that? And when you
What line? Where is that on the page?
it's I think it's like the second line of that paragraph.
Of the top first paragraph or the second paragraph?
Let's see here. Got a couple of different documents open here, so bear with me.
We're still on page 14 of 24, right?
We're on the page the page that talks about analysis of impacts. That would be excuse me, page 13
13, okay.
of 20. Is that 13? I'm having a little. No, it's page 14.
14, page 14, and the
Page
page numbering
14,
I
the
use.
under new jobs, the second line, it says BCP's relocation, and then onto the third line of employees to New Mexico.
It's page 14 of 24 or page 11 of the on the body of the report.
I'm still not seeing it. I'm sorry.
Look on the share screen.
Okay. I mean, I'm on the right page. Oh, okay, I see it. All right. Okay. Yes, I see it now.
Okay, so my understanding is that that is because these jobs were originally in New Mexico before Emera acquired New Mexico Gas Company. Is that right?
That's my understanding, yes. That
Okay.
understanding is based on testimony I've listened to over YouTube this week.
Okay. Now, these 20 new or 21 new employees, they will be paid, right?
Yes,
And they will have benefits,
I assume so.
and New Mexico Gas Company will pay their salaries?
I'm not sure what the arrangement is. My understanding is that there's some sort of shared services agreement and that New Mexico Natural Gas will pay a fee of some sort, but I'm not privy to the details of that agreement, or I'm not even sure if the details have been worked out.
Okay, well, let's assume that that New Mexico Gas will pay the salaries and their benefits.
Okay.
And um, and then these new employees will need offices, correct?
Well, yes, and yes, that's correct.
And computers and office furniture and office supplies. Is that correct?
Yes.
And uh, do you know, will New Mexico Gas Company pay for the office supplies?
The same answer to before. My understanding is going to be some sort of joint agreement, and I don't know the details of that.
Okay, well, let's assume that New Mexico Gas Company is going to do so.
Okay.
And then
Is that a question?
that is an assumption that I'm asking Dr. Erickson to make for purposes of my my next questions.
Okay.
Understood.
Okay, and then is it your understanding that New Mexico Gas Company, to the extent that it pays the salaries and the cost of the offices, will seek to recover those costs from its customers?
Well, I'm not sure these are new costs. They're new employees being relocated to New Mexico, but my understanding is that these are necessary employees who are doing services that need to be performed, and those services need to be paid for. The difference is the expenditures in New Mexico instead of not New Mexico. And so the benefit is from moving them to New Mexico. And I'm under the impression that the total net employment is not changing, is the net employment in New Mexico, which is then offset somewhere in some other state, or maybe it's in Canada.
Okay. Okay, let's move on. Let's move to page 15 of your report, which is also labeled as page 18 of 24. Okay.
Okay.
Now, I want to look at table 16, 17, and 18. Now, that shows the tax impacts of the 20 new jobs, the economic development contribution, and the rate credit. Is that correct?
That's correct.
Okay, now there's a column there for federal taxes. Do you see that?
I do.
But federal taxes are not necessarily spent in New Mexico, are they?
That is correct. They are not necessarily spent in New Mexico, but of course, we're not counting those as part of the economic impact. We're calculating those separately.
Okay. Thank you, Dr. Erickson. I have no further questions.
Thank you, Mr. Tessalin. Mr. Freeman, I believe that you reserved 15 minutes for Dr. Erickson.
Yes, Hearing Examiner Hurst, can you hear me?
I can.
Okay, I'm having computer issues, so I can't see you, but I can hear you. FEA has no questions for Dr. Erickson.
Thank you, sir. I believe that brings us to staff. Mr. Friedman, staff have questions for Dr. Erickson.
Thank you, Hearing Examiner Hurst. Yeah, I have maybe one, maybe three questions.
Go ahead, sir.
Good morning, Dr. Erickson. My name is Ryan Friedman. I represent staff this morning.
Good morning.
And I just had a couple questions in regards to your economic development testimony. First being, are you personally familiar with the plans in place for the distribution of the economic development money?
I am not I'm not familiar with those plans, and my understanding is that is not necessary. Those plans have not necessarily been determined yet.
So if I asked you any questions in regards to how the applicants plan to use that money in economic development, would you have any idea
I
of how
have
to answer those questions?
I not really. I have heard some discussion of the way it was done previously, and I don't know if that's a good model for how it's going to be done in the future or not.
I have no additional questions, Your Honor.
Witness.
Thank you very much, Dr. Erickson.
Thank you.
Thank you, Mr. Friedman. Unless I missed someone, I do believe that concludes the cross-examination for Dr. Erickson.
Madam Hearing Examiner, this is Hearing Examiner Schaefer. I have several questions.
And I was just about to say that, Hearing Examiner Schaefer. Sir, please go ahead.
Thank you. Good morning, Dr. Erickson. Thank you for being here with us today.
Thank you. Thank you for having me.
I'm curious about the authorship of the report. Are the three of you involved in a LLC or in a business corporation, or were all three of you paid individually?
We're all paid individually. I think our agreement is that I'll be doing the billing and that I will issue 1099s.
Okay. So whose license did you use for this report?
That's a very good question. I did not use, we don't have a license.
For Implan?
For Implan, we used the license that we have available through the university. We did check the license to make sure it was usable for this purposes, and it is.
So the university Implan license is available for private use?
It's available for use by faculty in doing research, which this counts as.
Your own personal business purposes?
I don't view it as being used for personal business purposes in the way you're saying.
Oh, was the university paid for this report, or were you
University's
paid for this
being
report?
paid, is being reimbursed for the use of their space, and that'll be a check that I write to them, which I do whenever I consult using university resources.
I see. So the university is being reimbursed for this
Being reimbursed
license.
for the use of university services, yes.
Okay. The use of Implan, can you describe how that works exactly? The input-output model and
Yes, so the way it works is that Implan looks at data that they gather from different sources, and they, in some cases, they take national data and then they adjust it for local purposes. In some cases, they gather local data to develop spending patterns, and they use these. So in some cases, it's industry standards are developed on a national basis that are then scaled for New Mexico in this case. And in some cases, they find some data that's available locally for scaling for a particular industry. With this, they create an input-output model. They also look at spending patterns, for example, using gross receipts tax data, using tax data available from the state to look at spending patterns between. Also, I think they use travel data too. And they use that to estimate spending patterns between the counties. That spending pattern then is used to estimate the flow of expenditure between the counties. In the approach that we used, we then aggregate that spending at different counties to get a state level estimate. So we start with the fact that it's located in Bernalillo County, and then we look at the spending patterns that flow from that throughout the state. Of course, obviously the biggest impact is in Bernalillo County, since that's where the actual spending is occurring. But then we look at the flow that's aggregated together, and that gives us the overall estimate. This data that I've just described and the way it's collected is used to create a matrix. That matrix is called an input-output matrix, and that matrix is used then to actually do the calculation.
And that matrix is a proprietary matrix held by the Implan Corporation?
That is correct.
And the license is to be able to input specific data into that proprietary input-output model and then produce results. Is that correct?
Right. And we're also able to look at the multipliers and the coefficients and potentially modify them if we have reasons to believe that they're incorrect. But we're not allowed to publish them.
Right. What inputs did you and your team have to put into this Implan model?
Well, we put in, of course, the employment. We selected the industries which the employment was in. And of course located in Doñana County. And then later on, when we were doing the impact of the rate rebate, we located based on data given to us by New Mexico by the joint applicants. And I think it was actually BCP that gave us that data directly at that point. It wasn't joint applicants yet. We located the customers in each of the counties in which they were located. We used two categories, residential and commercial. We felt that was important to do because particularly for households, spending can be is different depending on income levels, and income levels vary by county in New Mexico. So we're running a model for each county based on the number of customers in those counties, aggregating that together to get a state level estimate.
Thank you. Dr. Erickson, you just said that we ran a model.
Well, literally Dr. Winningham ran the model, but he and I discussed how to run the model.
Okay, thank you. I guess my question, Dr. Erickson, is that isn't the model residing in the software with Implan?
Yes, that's correct.
And the users, in this case, Dr. Winningham or you, Dr. Erickson, are putting in data that's provided by joint applicants, the gas company or BCP. Is that correct?
That's correct.
And other macroeconomic data or regional economic data that responds to the scope of the analysis. Is that correct?
That is correct.
And I'm curious about one area that is Implan only used by economists, or is Implan able to be used by a lawyer, for example?
That's a good question. You don't have to have an economics degree to use it. I do believe the economics training better prepares you to use it correctly. For example, in this example, when we did the rebate, we knew not to use we knew that there was a distinction between having it be a transfer payment, which does not involve direct expenditure for goods and services, but it was just a transfer to households and to businesses. And we knew not to treat that as a transfer payment to households for the part that going to households, and therefore and not to treat it as if it was an expenditure on goods and services. That's an example of something an economist, and there's no reason to think that a well-trained person other than an economist wouldn't know that, but I think being an economist prepares you for that kind of issue when it comes up.
So having an economics background and expertise like yourself and your team helps better narrow or refine the data that's inputted, which then presumably helps refine the results. Is that correct?
That's my opinion. Yes, I think that is a correct assessment of the situation.
Just draw your attention now to your report briefly. If you could look at the page 9 of the actual report, at the lower part of the page, the renewable energy contribution description.
Yes.
And if I'm reading it correctly, and tell me if I am, it says NMGC's proposed 5 million renewable energy contribution has the goal to advance or develop renewable energy projects
I'm
designed
sorry,
to
contribution. I'm sorry, Judge. Can you slow down a little bit?
little
5 million
caffeinated.
people.
Good reminder for us all again to speak
Yeah.
slowly for Mr. Lee. Energy contribution has the goal to advance or develop renewable energy projects designed to align with the environmental goals of New Mexico. The economic impact of this project was estimated based on a typical solar facility that could be built for $5 million and the associated operations and maintenance, O&M, employment levels. So my question is that correct, firstly?
Yeah, that is
Dr.
correct.
Erickson? And what was the origin of this supposition, or the origin of using a solar energy facility at $5 million for this part of your analysis?
Yes, and could I go back and say a little bit more about my I'm sorry if this is out of order, but I did notice that and I forgot to mention this when we were talking before. You asked me about implant, but of course we used a different model for this part of the report.
Yes, absolutely, Dr. Erickson.
Yeah.
Just also to say, for the sake of the hearing and inquiry, please, if you feel the need to clarify or add more detail,
yeah,
go ahead, Dr.
Well,
Erickson.
we use the NREL model for the solar power because that's a specialized model for the energy sector. And again, we have access to that. It's of a kind with Implan, but it's specialized energy, so we thought that was a better one to use. It takes, for example, into account the grid and the constraints the grid's placed on expansion of solar power, as an example why it's a better model to use. And then if we could go back, and then that's what I wanted to add.
Thank you. The question was, where did this solar energy facility hypothetical come from?
It came from BCP and the joint applicants.
So BCP told you that they wanted you to model a hypothetical $5 million solar energy facility.
They didn't say a single plant, but it actually doesn't matter if we did one or several, but it's a little bit easier to model one than it is to do several. But that's what they said. They expected most of that to go to solar, to solar power. If they had told us it was going to go to other uses, we would have modeled it differently.
With respect to the economic development impact analysis, were you able to ascertain with certainty the impact of that program in your report?
I'm not sure what you mean. None of this is certain. These are all estimates based on the programs that were proposed that we were asked to analyze. Their estimates are not certain, but within they're reasonable estimates. When it came to the economic development program, is that what you're asking about?
Yes, that's correct.
Okay. There we modeled the administration of the program, not the impact of the actual projects being funded. And the reason why we did that is because we don't know what projects are going to be funded, and it makes it not possible to really model the impact of the actual projects funded, the actual grants awarded. And so we're looking at the administration of the program, not at the actual program itself.
And by the administration of the program, what do you mean by that
I mean,
specifically?
the people who give out the grants, who monitor the grants, to ensure that the grants are meeting their goals and expectations. If you want the people to do the paperwork.
The impact model and the report then models the impact for the employees and the cost of employees in administering and managing that program. Is that correct?
That is correct. And my understanding, that'll probably be given as contracts to other organizations, not done directly by New Mexico Natural Gas, but I'm not sure that even has been fully determined yet.
Dr. Erickson, were you and your team hired as independent evaluators of the proposed impacts, or did the joint applicants ask you to come to any certain conclusions?
We were not asked to come to any certain conclusions. And in fact, I've been doing various studies like this well, I did my first one in New Mexico about 37 years ago. I have a long and hard to develop reputation, and I would never compromise that. If a client asked me to do something like that, I would refuse the client.
Dr. Erickson, are there any limitations to an input-output model or in plan?
Yes, there are. First of all, these are estimates of the programs that we were told are proposed. If there were changes in the programs, if there were alterations of programs. For example, I've been told that the rebate now is going to be 22.4 million instead of 50 million. That's a different number. The numbers we have here are no longer correct. I will say it would be easy to change them, and it would just be, you just would scale them up. So that's certainly a limitation, is the assumptions that are made, underline them all there. And then implant itself assumes that prices are constant, that there actually are 20 employees out there to be hired, and that wages won't be raised, that prices won't be raised as a result of this project. And I think in this case, when it's a small project like this of 20 employees, that's a reasonable assumption. But in other settings, if you had a large factory coming into a community, that might not be a reasonable assumption. And so that's a limitation. And of course, it's an input-output model, and it assumes that the technological relationships in the production process remain constant, which, again, over a short period of time, that's reasonable. Over a 20-year period of time, that's not reasonable. And so the model is, I would call it, it is an equilibrium model, means the ultimate outcome, but I do think it's a model that used correctly, which we did in this case. It is valid in this case. It is useful, and it can give you insight into the impact of a project on the economy, but it has its limitations.
Thank you, Dr. Erickson. I believe you have a very important appointment this weekend, and I congratulate you for that.
Thank you.
Please accept those sentiments, and also for the appreciation for your time and energy on this report, and for speaking with us today.
Thank you.
Thank you, Hearing Examiner Schaefer. Dr. Erickson, I just had one question or request for clarification. In responding to Hearing Examiner Schaefer's questions about implant and the inputs, you answered, we put in, of course, the employment. We selected the industries which the employment was in.
Yes.
Of course, located in Doña Ana County.
Yes.
That was your testimony, sir?
Yes.
And does New Mexico Gas Company serve in Doñana County?
Did I say Doñana County? I meant to say Bernalillo County. Thank you, Madam Examiners. It's Bernalillo County that they're going to be located in.
Okay.
Yeah.
Thank you. I was a little confused there for a moment.
My home is located in Doñana County, but the jobs will be in Bernalillo County.
Very well.
Yeah.
Thank you, sir.
Thank you.
Mr. Alvidrez, any redirect based upon the cross-examination or the hearing examiner's questions?
What's actually based on Mr. Gould's question. So if I may, Dr. Erickson, you recall Mr. Gould asked you about labor income with regard to the 20 jobs.
Yes.
And there was a $2.3 million figure and a $3.6 million figure. Can I have you look at page 11 of your report or page 14 of 24?
Yes.
And there's table 8 there.
Yes.
Can you take a look at that table?
Yes. I'm looking at it.
And do you see the under the column labor income?
Yes.
And what do you see in that column?
2,361,960.
Okay, and going down?
569,452.
Keep going.
670,239.
And then the total?
3,601,651.
Does that explain the difference?
Yes.
Between those?
So the two, yes, it does. Thank you. The 2.3 million is the amount of labor income being paid the employees directly, and the total is 3,601,000, which includes the direct, indirect, and induced values.
Thank you very much. That's my question, Your Honor.
Thank you, Mr. Alvidrez.
Yeah.
Any further questions based upon the redirect or the hearing examiner's questions? Raise
Madam
your
Hearing-
hand,
Hold
Mr.
on.
Gould.
Yes, one question, and Dr. Erickson, the 2.361960 figure.
Yes.
Just to be clear, that would be what gas company, New Mexico Gas Company is going to pay those 20 employees direct their salaries or their hourly, including any contribution that the company makes on a pension, any contribution, any payment they make to Social Security on behalf of that employee. I'm really looking for what is the cost to gas company, total cost on an annual basis under your best estimate?
Well, again, I'm not sure it's going to be paid directly by New Mexico natural gas, but having understanding that the nature of your question, that is correct. You're correct. That is the labor income, which is the wages and salaries, pensions, benefits, and so on.
Thank you. That's all I have, Madam Hearing Examiner.
Thank you. Anything further? Seeing nothing, Dr. Erickson, thank you, sir, for your time. As hearing examiner Schaefer indicated, we hear that you're off for a joyous occasion. So congratulations, sir, and you are excused.
Thank you.
I believe we will be returning at this point to our cross-examination. Of Mr. Shell. And as I indicated this morning, I believe, Mr. Yar, you have 75 minutes remaining.
Madam Hearing Examiner, I'm happy to take the 75 minutes. I thought it was 45, but just want to make sure. I thought what I heard yesterday was I had 45 minutes left.
Okay,
Oh no,
That's
you're
fine.
correct. Someone just kicked me under the table and said, no, I used 46 minutes and I had 74 left. Yeah, you were correct. Thank you.
And Madam Hearing Examiner?
Mr. Dome?
Mr. Haverly will be coming back, and we'll need a couple minutes for him to come back into the room and get set up.
Should we take our break?
Okay,
Just a couple minutes, ma'am, that's all.
okay.
I just need to get Mr. Shell, Madam Hearing Examiner. This is Mr. Haverly. I'm getting Mr. Shell. We're going to get set up. It'll be a minute or two.
He's in here, Brian.
Okay.
Madam Hearing Examiner, if I may.
Mr. Yar?
I don't know what's on, from my perspective here, I'm seeing a portion of the joint applicants exhibit as a background and you're kind of in the center of it. Okay, perfect.
There we go. Yeah, I've been trying to work on this Zoom share presentation. I have not perfected it. And so yeah, I stopped the share.
Madam Hearing Examiner, can you hear us?
I can.
Excellent. I think we're all set here. And by the way, I was impressed with the background and the fact that you were able to have your image plus the background. I was going to ask you, you're going to have to share with that secret with us sometime.
It's really scary and I have no idea. Good morning, Mr. Shell.
Good morning, Madam Hearings Examiner. And
we're back. We're gonna continue your cross-examination. You understand, sir? You're still under oath.
I understand.
Very well. Go ahead, Mr. Yar.
Thank you, Madam Hearing Examiner. Good morning, Mr. Shell.
Good morning.
So from yesterday's cross-examination, we left off reviewing all of the individuals that provided provided expertise to the New Mexico Gas Company via Emera. Is that correct?
I believe we covered the folks that had come here from Emera or Tico and spent time here with the business, some of whom we hired directly just through our normal hiring process. But yes, we were discussing the folks. I think the question was how many people, or please describe all the people who have come to New Mexico Gas Company from either Tico or Emera. So that's what we were attempting to do in that response.
I would like to correct you, sir. The actual response, if you could take a look at it, it's NM Area Exhibit A. 8. Sorry, 8.
All right, we'll have that in a second.
Sure.
All right, I have it here.
And it's your response. I'd like to point you to the last sentence in the question, and I'll read it for you. It says, in your response, please provide a description of the expertise that the individual brought to New Mexico Gas Company and any improvements they made to the management or field operations of the utility. So, Mr. Shaw, I just want to repeat my question. Those individuals that we talked about yesterday, they did in fact bring expertise and made improvements to the field operations of the utility. Is that correct?
Yes, that is correct. We hire lots of people every year. The expectation is they all bring expertise to the business. So,
thank you. And those individuals specifically came from Emera or Tico. Is that correct?
yes, they came in different ways. You had referred yesterday to some of the people later in the description. the HR analyst and the acquisitions representative. Those individuals actually just applied for a job in normal course here, but we wanted to make sure we were wholesome in our response and making sure we're being responsive to your request. So those folks applied for a job that was here, and they were the successful candidate for those jobs. The individual DJ, who's the legal counsel, we had a situation where we had one of our legal staff go on maternity leave and was going to be out for 6 months maybe or so, and so we just reached out to Amira, said, you have someone that could come and just kind of fill this role for a period of time, rather than we could have went into the local market and used a local law firm, but we chose to do that, and so certainly that person brought some expertise at our request. And then we talked about the officer level employees in more detail yesterday, and one of whom is still here. But yes, they all brought expertise of some sort. They didn't come here to fill a void in any way in the management structure, and they all worked under me either directly or indirectly.
Thank you, sir. Along the lines of the expertise that we just talked about and the individuals, did Amira or Tico also provide what is sometimes referred to as shared best practices?
Yeah, when you're part of a larger organization like this, you often you're interacting with one another on a regular basis, particularly at the leadership level. So we would interact with other Amira affiliates, much in the same way I expect to interact with the Delta Utilities folks under BCP ownership. So I think we won't lose anything in that regard, because we'll be joining another family of utility companies that have operations in Mississippi and Louisiana. And I fully expect that I'll be interacting with Tim Poche, who's the president there, and making sure our leadership teams get together occasionally to talk about best practices and things like that.
Mr. Shao, I'd like to turn your attention to New Mexico Area Exhibit 8 again, more specifically Interrogatory 4-3. Can you read that into the record, please, that question?
All right. Please provide the description of best practices that TECO and Amera have shared and implemented with NMGC since the date the commission approved the TECO acquisition in case number 13-00231-UT. In your response, list the benefits and cost savings that customers have experienced as a result of these shared practices.
And Mr. Shao, you're the sponsor of this, the answer to this question?
Yes.
Okay. And going down a little bit further, one of those examples include an advisory board for capital projects. Is that correct?
Yes.
And that provided engineering expertise or best practices. Is that correct?
It was just something that TECO did in other affiliates that we decided to adopt here, where we set up an advisory board for larger capital projects. So we thought that was a good practice, and we implemented it here.
Okay. Maybe we can go ahead and read that one into the record too, sir. Can you start with the first bullet point?
The one that's advisory boards for capital projects?
Yes, sir.
Yes. NMGC's engineering department holds regular meetings to provide status updates on ongoing projects and troubleshoot issues as they arise. For larger projects, NMGC executives participate in advisory board meetings to monitor the status of projects and provide strategic guidance and oversight.
Thank you, sir. One of the other best practices that are outlined here is cybersecurity practices. Is that something that Amira also provided best practices for NMGC?
Well, in the world of cybersecurity, it's ever evolving. So there are cybersecurity best practices, and so we would interact through our shared service environment with TECO primarily, but also Amira to some extent, on, cybersecurity best practices. Our IT department would interact with the IT department at Tampa Electric and just ensure that we are following best practices as they may be outlined by different organizations that specialize in best practices on cybersecurity.
Thank you, sir. And then additionally, there were leadership competencies also that were provided by Emira as best practices. Isn't that correct, sir?
Yeah, we listed that here. During the course of ownership under Emera, the affiliates all got together and developed these leadership competencies, and we try to use them consistently across all of the Emera affiliates. But yeah, that was developed by the affiliates in conjunction with one another, and we use it still today in terms of how we evaluate leaders in the organization and what the expectations are around our leaders in the organization. I would expect we will continue to do similar things as we move forward under ownership by the BCP funds.
So, Mr. Shaw, you would agree with me that Emira has been a strong and consistent owner of New Mexico Gas by fulfilling and supporting the companies through these practices. Wouldn't you agree with me, sir?
Yeah, certainly. It's given us the opportunity to work collaboratively across the Emera organization and observe best practices, and they observe best practices here as well, and use them in their organizations as well. So yeah, anytime you're in part of an organization that includes multiple utilities, you tend to want to get together and talk about these sorts of things. And again, I'll just point out that under the ownership that's structure that's being proposed in this transaction, we would have the same opportunity, obviously, with the utility operations in Mississippi and Louisiana. So I'm actually looking forward to interacting at a deeper level with those organizations.
Since Emira's acquisition, Mr. Shell, in 2016, Emira has consistently approved NMGC's budgets. Is that correct?
Our board has approved our budgets.
Okay. And does Emira have any representatives on that board?
Yes, there are two individuals who also are Emera executives on our board.
Okay. And to your knowledge, has Emira ever told you or anyone on your management team that it intends to stop investing in NMGC?
No.
Okay. If this transaction were not approved, NMGC would remain a regulated utility owned by Emira, correct?
Yeah, if it's not approved, obviously we remain under the ownership of Emera.
And you would expect Emira to still be obligated to provide adequate service and make prudent investments under the commission's rules, right? Correct?
Yeah, any owner of this business, that would be my expectation of the owner of this business. So yes, I would expect that that Emera would they have committed in their acquisition case to recognize this commission, so I would expect that to continue.
So as far as you know, New Mexico Gas Company's investment and service commitments would continue under Emira's ownership as they do today. Is that correct?
Yeah, could you repeat that question? I just wanted to.
Sure. It dovetails off the previous question. Do you want me to repeat the previous question also, or just the last
No,
one?
just that last comment. I just wanted to.
So as far as you know, New Mexico Gas Company's investment and service commitments would continue under Emira's ownership as they do today, correct?
Yes, that would be my expectation under any owner. The local management team really drives that sort of activity in the business, and our expectation would be that our owner would support us on that.
Mr. Shell, thank you. That's it for me. That's all the questions I have.
Thank you.
Thank you. Mr. Yar.
Madam Hearing Examiner, I have one procedural question.
Yes, sir.
Okay. I would like to move into the record New Mexico Area Exhibit 8 with, and not the entire exhibit, just the questions and answers to interrogatory 4-4, 4-3.
And I'm assuming there's more than one. Are those the only interrogatories comprised?
That's correct. No, let me make sure I understand your question, Madam Reserve. NM Area Exhibit 8 has all of the interrogatories 4, but I'm only moving in 4-4 and 4-3.
Then, as I indicated to Ms. previously, if you're only moving part of the interrogatory, then I want it separated out as a separate exhibit. Unless you're going to move the rest of it in at a later date.
No, I believe those will be the only two, and we will do that, Madam Hearing Examiner.
Okay. Thank you, sir. Okay, well, according to the cross-examination schedule, Ms. Nanasi, how much time did you have 20 minutes left from your already used time?
It's either 20 or 25. If I can, give me 1 second and I'll go look at how much
Actually, mine says minus 20, so I think you'd be correct.
Okay.
25.
That's what I thought. Thank you.
Okay.
My records also show, Madam Hearing Examiner, Brian Haverly, that Ms. Nessie has 25 minutes.
Okay, great. Thank you.
You want for me to start?
Mr. Lee, do we want to break now? Do we want to break in 20 minutes?
Now would be good.
Okay. All right. We will go ahead and take our 10-minute recess. Come back at a little over 10 minutes. We'll come back at 10:35 and then you can ask your questions. Remember that the YouTube is on, please. And also you might want to mute your put your mute on.
Can you fill this with water?
Mr. Lee,
Yes, Judge.
how are you doing?
And I'm ready when you are.
Okay, I just lost one of my notes. Hold on just a second. Okay. All right, Miss Nanasi, you have, what did we say, 25 minutes?
Yes, ma'am.
Okay, go ahead, please.
Good morning, Mr. Shell.
Good morning, Miss Manassi. Good to see you.
Good to see you. You were involved in the Tico case, were you not?
Yes, I was.
And you were involved in the Amera case also.
Yes.
You were also intimately involved in the last two rate cases for New Mexico Gas Company, correct?
Yes, I was definitely involved in them. I don't know if I describe it as intimately, but I was involved.
I would describe it as intimately then. Okay. Both of the last two rate cases were settled. Is that correct?
Yes, we did reach settlement with the parties.
Okay. In the last rate case, the New Mexico Gas Company was allowed a $30 million rate case. And to be specific, for the record, that was in case 23-00255 UT. Is that right?
Yes, we agreed in that case on, among other things, a $30 million rate increase.
And the rate case before that was the New Mexico Gas Company was allowed a $19.3 million rate increase, among other things. And that was in case 21-00267 UT, correct?
Yes,
And you were part of those negotiations, correct? In both of those last two rate cases?
yes. At various points, I was involved in those negotiations.
And those negotiations, you were engaging with interveners and staff, correct?
Yes, I was through my attorneys.
And persons from Emera?
Not necessarily. I think we would occasionally, as we were close on a settlement, we would reach out and let them know where we were at.
Okay. Without getting into any settlement discussions, or individual persons, is it true that you and your attorneys discussed specific matters like the exact amount of the rate increase, like the exact amount of the ROE, and other specifics?
Objection, Brian Haverly.
I'm not
Mr.
done.
Haverly?
Attorney-client
Oh,
privilege.
you're not,
Can I finish the question?
have you got your question? Let her finish her question, Mr. Haverly.
I thought she had. My apologies, Madam Hearing Examiner.
Okay.
I heard, is that correct at the end?
With Emera?
No.
And that's the question.
Could we please repeat that question or have it read back just so I understand?
It says, without getting into settlement discussions or individual persons, is it true that you and your attorneys discuss specific matters like the exact amount of the rate increase, like the exact amount of the ROE and other specifics? And then she added with Emera.
Correct is the next word.
Objection, Brian Haverly.
Okay, and Mr. Haverly, what is your objection?
That would be the attorney-client privilege, Madam Hearing Examiner, the discussions with counsel about the aspects or any type of topics that were discussed between Mr. Shell and his counsel are forbidden from being disclosed, and I would lodge my objection on the attorney-client privilege. If she wants to just know what was discussed between Mr. Shell and Emera, I have no objection.
Ms. Nanasi, what is your response to the objection?
I'm not asking for anything that was said between him, Mr. Shell and his attorneys, or Mr. Shell. Well, I am asking about Mr. Shell and Emera about those specifics. And I don't want to know about the specifics. I just want to know if that conversation happened.
Mr. Haverly?
Madam Hearing Examiner, again, if it's just the discussions between Mr. Shell and Emera, I have no objections. The way that the question was phrased involving the attorneys concerned me, but if Ms. Nanasi is simply asking about the information between Mr. Shell and Emera, I have no objection.
Is that what you're asking, Ms. Nanasi?
I'm asking about it all, and in the context, what the question right before that was, when we were negotiating the settlements in those rate cases, didn't you have a conversation about the specifics of in those rate cases with your attorneys and persons from Emera? And that's all I want to ask. There's nothing else besides that.
Right, and he's objecting on attorney-client privilege regarding the specific categories that were discussed between the attorney and the client. Is that right, Mr. Haverly?
Yes, ma'am, as the shareholder, as part of the board, that's where my objection is. That's also entitled to attorney-client privilege. So any discussions between Mr. Shell and the shareholder or the board members while the lawyers were involved is protected by the attorney-client privilege, including what that subject matter may have been about. If it's just simply a discussion about Mr. Shell's communications individually with the board members or mayor representatives, again, I have no objection. But to the extent that this involves attorneys, I lodge strongly my objection based on the attorney-client privilege.
I'm going to sustain your objection, Mr. Haverly, with regard to any type of attorney-client privileged communication between Mr. Shell during the negotiation process during the rate case.
And sir, what
Ms.
about,
Nanasi?
thank you. But what about conversations that you had with Amira during that process? You did have conversations with Amira during those processes. Is that correct?
When you're referring to processes, you're talking the settlement discussions?
In the rate case, yes, in those rate cases.
I don't know that I had separate discussions with any of them. The negotiations for the rate case settlement were handled here locally with my team and through my attorneys.
And your team included non-attorneys, isn't that correct?
The executive team here, yes.
And what I'm just trying to figure out is, did you communicate with your team and Amira during those processes?
At the end of the process, where the team here felt we had a settlement, we did reach out and talk to the board chair, the New Mexico Gas Company board chair, who is an executive at Amera. And that was at our board meetings, we discussed how we would handle a rate case settlement. And the board concluded that as we got close to settlement, that we just inform the chair of the board on where we thought we were going to land on that. So that's what we were doing.
Given your specific experience with this commission, when do you expect this case to be finalized after this hearing, briefing, response briefing, the hearing examiner's recommended decision, exceptions, the commission decision? When do you expect that all to culminate?
Objection, Brian Haverly.
Mr. Haverly?
The objection is based on speculation, Madam Hearing Examiner. I think there is no time frame whatsoever for the commission to make a decision. The value of asking Mr. Shell to speculate is not probative in this case. So there's a relevance objection and a speculation objection.
Ms. Nanasi?
If you recall, I asked Mr. Shell, had he been involved in the TICO case? Had he been involved in the Amera case? He said yes to both. He's been involved in both last rate cases. He has extensive knowledge in this commission with these kinds of cases. And I asked him, you know what the process is. I set those forth in my question. When do you think that this is going to culminate? If he doesn't know, he doesn't know. But if he knows, I want to know what that answer is. And I said, given your specific experience, that was my question.
So what is your legal response to Mr. Haverly's objection of relevance and speculation as the basis of his objection?
I'm absolutely asking him to speculate. There's no question about that. There's no reason that I can't ask him to speculate. I'm asking him, does he estimate? That's allowable. Why is it relevant? Because because I want to know if, and I will get into this right next, if the rate freeze that is being offered in this case has any actual monetary value as a benefit. So that's where I'm going next. And also, I just want to say, we asked basically every other witness throughout, when do you think this case is going to culminate? I only set it up with him because he actually has experience in that.
Anything further, Ms. Nanasi?
Nothing.
I'm going to overrule the objection. I believe that the witness can answer if he knows, and I think that there is relevance in determining some of the value of the commitments that have been proposed. Go ahead, Mr. Shell, if you know.
Well, she mentioned my experience in rate cases and in prior acquisition cases. My experience in the rate cases, obviously, there's a timetable set by the commission to rule on a rate case, so it's a little more straightforward. In this case, there's not necessarily a timetable, so that makes that a little harder. Also, in prior acquisition cases, we've settled them, and so to me, that puts it on a little different timetable. But overall, I think as we talk with my attorneys here, we think perhaps as early as at the end of the first quarter or something like that.
Is that a basic about April?
Yeah, I said the end of the first quarter, so that could be in the March timeframe or in or about that timeframe.
Okay, thank you. And you said yesterday that a normal future rate case takes about 5 months to develop?
Yeah, if you without a lot of advanced planning, I think I said it takes about 5 months to kind of start to finish to get one of those put together. If there is advanced planning involved in that, it can be shorter.
You'd agree that the commission's prior acquisition approvals, and I'm going to name some cases, 08-00078 UT, 13-00231 UT, which was TICO, 15-00327 UT, which was Emera, 19-00234 UT, which is JP Morgan and EPE, and even Avangrid's 20-00222 UT, all included actual enforceable rate freezes as one of the benefits that were in those cases. Is that correct?
I haven't reviewed every one of those cases, but I can, I guess, take your word for that.
Okay, but for instance, specifically about, you said the TICO and Emera cases, those did include a rate freeze. Is that right?
Yes, they did.
So, sir, I don't want to, if you think, I'd like to assume that March was the culmination of this case. Would that be fair? Sometime in March.
Yeah, that involves a lot of speculation, I guess, and I'm not sure when we get the hearing examiner's report. I'm not sure what it's going to say. Then ultimately, the commissioners get to rule on it. But yes, I think we're thinking in the March timeframe.
Okay, so if we add 5 months to March, that would be April, May, June, July, August, right? 5 months. So the earliest that an MGC could file a rate case would be September 1st, let's say. Would that be a fair guess?
I think we could probably file earlier because what we're doing right now in the business is we're planning to file. And for example, my finance team here in the organization is actually updating 6:30 schedules as we're going along because we don't know when we're going to file, and it's very possible we could file sooner than what has been offered as a stay out, especially if this case gets denied. So we're going to want to file pretty quickly if that is the case. So they've been doing the work. We've been already reaching out to consultants and working with our consultants that we normally use in a rate case. So given all of that, and given the fact that they are actually keeping the 6:30 schedules, which are, as you know, a very big part of a rate case filing, they're keeping those up to date on a month-by-month basis. I think under your hypothetical where it's in the March timeframe, I think we could actually file in June. So
Okay.
we would use a December year end.
Okay. If that were to happen,
Wait 1 second, Ms. Nanasi. Just so I understand this, Mr. Shell, am I understanding your testimony correctly that gas company is in the process of compiling its information to file a rate case in the event or to be prepared to file a rate case in the event the commission denies the transaction as early as June?
Yes.
And I've heard testimony that the potential rate case associated with, I guess, approval would be a future rate using a future test year, correct?
Yes.
Would the one that potentially gas companies working on now that it might file as soon as June if the transaction is denied, would that also be based on a future test year?
Yes, it would. We've set up we are structuring most of our rate cases going forward. In fact, all of them, we intend them to be future rate cases.
Future test year?
Future test year rate cases, yes.
Okay. Thank you. I'll start your time back, Ms. Anasi. I had it on hold.
thank you so much.
Go ahead.
Do you know that in the 1500327 UT case, that as one of the benefits of that case, Emera agreed to a historic test year, to use a historic test year in its next rate case?
Yes, I'm familiar with that.
And do you also know that that was true in the 19-00234 UT JP Morgan EPE case, that they agreed in that case to also use a historic year as opposed to a future test year for the next rate increase?
Yeah, I'm not, to use one of your words, intimately familiar with the EPE final order, but I can take your word for that.
Okay. Could you turn, please, sir, to New Energy Exhibit 7? And if you wouldn't mind, can you use the updated one that I put in Dropbox?
Okay, we're working on that.
Thank you. Can I ask you a question while somebody's helping you get that?
Yeah, certainly.
Okay. I wanted to talk to you about Storm Uri. You remember that, right?
I do.
Okay, and that was in 2021?
Yes, it was.
And in advance of Storm Uri, did NMGC have conversations with Emera about how to best address the potential threat to the gas supply?
You know, I don't specifically remember. Well, let me put it this way. I may have talked to the board chair. I don't know, but it wouldn't have been to get advice or anything like that, like you're indicating in your question. The team here essentially handled all of that. And to be frank, I don't remember whether I would have talked to the board chair in advance of that or once we were in the middle of it. So I don't recall, but there was probably an outreach at some point in that process.
Sir, you know that there was basically $100 million approximately, I think it was 107, but that was needed by NMGC to pay for that gas supply.
Yes, I am aware of that.
Where did that money come from?
So initially, our gas suppliers, because of our credit arrangement with our gas suppliers, we wouldn't have had to pay for that for, I believe it's, and I don't remember specifically, but usually the gas we pay for in 1 month is due on the 25th of the next month. So we would have been able to finance that actually through our gas suppliers for the first period, but we actually went into the market and got a term loan and utilize the term loan to get the funding to then pay the gas bills.
If this transaction proceeds and is approved, do you expect that you could go or would go to Saturn Holdco, or would you go back and go back to the open market to get a term loan that you discussed?
I think we handled that situation appropriately, and I would, as if it were to occur again, we would probably do exactly what we did in the last instance. We would, as a company, New Mexico Gas Company, we'd go and enter into a term loan with a third party.
Okay. Do you have that NE Exhibit 7? How many more minutes do I have, Madam Hearing Examiner?
3.
Okay. Could you open up New Energy Economy Exhibit 7, and could you ask your helper to please get up New Energy Economy Exhibit 11 while we're talking about New Energy Economy 7?
Did you hear that? Okay. Yes, they're working on it.
Thank you, thank you. So could you please look at New Energy Economy 7 and just, could you, is it true that you were the respondent in New Energy Economy 1-33, 1-35, 1-38, 1-42, and 1-45?
I apologize here. Hold on. This is involving a lot of scrolling up and down here. So where'd you start? 1-33?
Yes, then 135.
Just a second. I'm still trying to get to 1-33. Oh, here we go. Yes, I am for 133. I am the sole respondent.
And then 135.
Yes, I am a respondent on that, as well as Jeff Baudier.
And 138.
I'm the sole respondent on that one.
142.
On 142, I'm responding as well as Jeff Baudier.
And on 145, it's the same as well. Mr. Baudier and you are the respondents, correct?
Yes.
And in fact, at the end, you provide a self-affirmation that says, I know the contents of my respective responses and they are true and accurate based on my personal knowledge and belief.
That is true.
Okay, can you look at New Energy Economy Exhibit 11? And could you please turn to New Energy Economy Interrogatory NE 8-10? You were the respondent there as well. Is that correct?
Yes.
And also with that response, you provided a self-affirmation again that says, I know the contents of my respective responses and they are true and accurate based on my personal knowledge and belief. Is that
Yes.
right? Thank you. Sir, in the LNG case, which for
That's
the
a
record,
question.
thank you. In the LNG case, in the LNG CCN case, and for the record, that was 22-00309 UT. The PRC made clear that for discretionary projects, the applicant bears the burden of proving the net public benefit with a cost benefit analysis that is timely. Is that correct?
Objection, Brian Haverly.
Mr. Haverly?
Calls for a legal conclusion, Madam Hearing Examiner.
Ms. Nasi?
I didn't ask him to conclude anything. I asked him, is that the fact? He was involved in that case, and I'm sure that he reads and is familiar with the orders of this commission. If he's not, he can say he's not familiar with the orders of this commission, but I think he knows the answer to that question. And I'm not asking him as a lawyer. I'm asking him as the president of New Mexico Gas Company.
Mr. Haverly?
Madam Hearing Examiner, she's asking him to interpret the commission's orders, asking, didn't the commission make it clear in an order that certain requirements are going to be necessary from the commission? I think that's a legal conclusion. I think that's calling for Mr. Shell to make a legal conclusion about the requirements that the commission is going to put upon people going forward in applications.
Can I respond, Madam Hearing Examiner?
Yes, ma'am.
He's the president of New Mexico Gas Company. If he doesn't understand that order from the commission, whether the commission is going to approve a project or not, that would seem to me to be, you know, a lack of responsibility for the president of the company. I mean, this is not the most complicated legal theory. It's basically I asked him, isn't that what the commission held about the project that NMGC was asking for? That they bear the burden of proving a net public benefit with a cost benefit analysis. It's clearly relevant, Madam Hearing Examiner.
Well, and I don't know that it is relevant, but there's not a relevance objection. But you know, that's what I'm wondering, where this case comes out of the blue. But I think with regard to the specific objection, I think it's your characterization of the commission's holding that Mr. Haverly objects to. And your question was, in the LNG case, and for the record, and you cite the case number, and you said the PRC made clear that whatever the discretionary projects, et cetera. And so that's the objection. I think it is a legal conclusion. And I'm going to sustain the objection, but I think that if there is some relevance, the question is, are you familiar with the commission's finding and order in case number 22-00309, Mr. Shell?
Is that a question to me, Madam?
It is a question.
Okay. I am familiar with the case, not necessarily all the specifics in the case. What I am familiar with is that ultimately the commission did not approve the LNG facility. And I don't have that order in front of me, so I don't know that I can recall all the specific things referenced in that order, but I do know that ultimately they did not approve the LNG facility.
Okay.
Can I have
Very
one?
well.
Can I have one
No,
follow-up?
no, your time is finished. I was
you.
pretty liberal with the time. Anything
you.
further, Ms. Nanasi?
No, thank you.
Okay, thank you. The next questioner, I believe, Ms. Beatles, you reserved 15 minutes.
That's correct.
Go ahead, please.
Thank you. Good morning, Mr. Shell.
Good morning.
My first question is, in communications to potential bidders, Emera provided a 20-year forecast of New Mexico Gas Company's capital expenditures. Is that correct?
I don't know that Emera provided it. It was part of the materials provided. JP Morgan, I guess what it's standard in these processes to provide a 20-year forecast. New Mexico Gas Company generally does like a 5-year forecast. So we didn't have information out 20 years. So during that process, I believe Emera probably, I don't know if it was Emera or JP Morgan, that hired a third party who has some expertise around this to actually project out 20 years.
And would you agree that a 20-year capital expenditure forecast is not routinely provided by New Mexico Gas Company to the commission as part of your rate case, IRP, or other filings?
Certainly not a 20-year. We do not provide the commission with a 20-year capital forecast.
What would you say today is the period that you have forecasted out capital expenditures in commission filings?
I would have to, well, clearly in rate cases, we forecast out through the end of the test year, and I would have to actually go and pull up some of the filings we make with the commission, either a FERC Form 2 or maybe a Class 1 transaction report that we file annually. I think in some of those reports we may put a 5-year forecast into those reports, but I would have to check them to verify that.
Did you just mention a Class 1 or 2 transaction?
I believe on an annual basis, we file both the Class 1 and Class 2 transaction report.
And those reports could potentially include a forecast out for 5 years. Is that what you're saying?
Yes, and I apologize. It's been a long time since I've I've worked or reviewed those things before they're filed. It was back when I was the VP of Finance, so I just can't recall where it might be. It's either at the back of the FERC Form 2, or it could be in one of these other reports I'm referring to where that gets filed. But I recall that it goes out 5 years, but so I hope that helps. I don't know with certainty, but I think it does.
So that's subject to check.
Yes.
Okay, moving on. Just to level set, Is it your understanding that the acquisition premium is the amount paid over utility book value and does not depreciate?
Yes, that is true. There's been a lot of discussion on goodwill in this case, and um, the way well, I don't even know if I go on to your next question.
Well, next question, are the terms acquisition premium and goodwill used synonymously?
I think in New Mexico we do use them synonymously. That's been my experience in prior acquisition cases. I don't want to get into details, but I think truly under FERC, there's a FERC account called acquisition premium. And so that's why I think in a regulatory setting, people tend to use acquisition premium quite often as a term, but truly from a generally accepted accounting principles perspective, it is goodwill. But we tend to use them interchangeably here in New Mexico.
And I expect that you did listen to Karen Hutt's testimony yesterday. Is that right?
I think I listened to most of her testimony. I might have stepped in and out a couple times, but I generally heard most of it.
Is it your understanding that when Emera agreed to sell New Mexico Gas Company to Bernhard Capital Partners for a price that did not cover the book value and the amount over book value that they paid when they bought New Mexico Gas Company, Emera had to record an impairment and recognize the loss?
Yes, in this transaction, this pending transaction, there is a forecasted loss, and in response to discovery, we refer to it as an impairment charge because that's how it's reflected on New Mexico Gas Company's books, and through the consolidation process that rolls up to Emera. But we had to essentially forecast out what the proceeds are going to be when this is anticipated to close. And in doing that, when you go through that process, there is a loss to Emera, and it gets recorded as an impairment charge. And I think when we've answered discovery in the past, we keep referring to it as impairment charge. And I think people have been confused, not recognizing that the impairment charge is a loss, is a GAAP-based loss that Emera is taking on the sale of this company.
And you can't reverse an impairment charge, is that correct?
You're right, you cannot reverse it.
So for example, if the sale gets denied, Emera can't undo that impairment charge, is that right?
No.
Know that I'm not right, or know that they can't do that?
I'm sorry. No, they cannot. You cannot then subsequently write up goodwill.
And you anticipated my next question in part because do both Emera and New Mexico Gas Company record goodwill on their books or on their accounts?
So this is another interesting thing about the goodwill. And I don't want to confuse the record any here, but when you buy a company, the goodwill gets down onto the lowest company in a process called push down accounting. I think we've discussed this in prior acquisition cases. So you technically don't have to do push down accounting. So you can actually leave the goodwill. The goodwill doesn't have to get pushed down to the ultimate bottom, the organization at the bottom of the ownership structure. In 2009, when we bought the business from P&M, we at that point in time, the accounting rules were pretty strict about pushing down accounting. Since that time, the push down accounting, a lot of companies don't push down. So you can have a lot of acquisitions today where they don't even push down the acquisition price and record the goodwill down on the company. But once you start that process, as we did in 2009, you can't undo it. So since we've been doing push down accounting through our various acquisitions, we've had to continue to do that.
What if you were to receive a commission order requiring that a Bernhard Capital Partners related entity, maybe the direct owner of New Mexico Gas, only carry the goodwill and not New Mexico Gas Company? If you were to receive such an order, could you then not carry it on in your accounts anymore?
I would have to talk with our auditors and have our finance team do some research on that. My my belief would be you could not, that would not be the case. But I don't know with certainty.
And my next question is, if the risk of gain or loss is on the holding company, then why is goodwill also recognized on the books of New Mexico Gas? Is there any reason other than that you started it in, I think you said 2000 or so?
Yes, that gets to the very point I was making, the push down accounting. So they acquired the stock of Tico, but through this push down accounting process, you push that acquisition down onto the books of the lower subsidiaries, and it gets recorded as goodwill. It would still be recorded as goodwill, even if you didn't do push down accounting. It would just get recognized at a entity further above New Mexico Gas Company.
Do you know whether other jurisdictions require that goodwill be carried on only by the holding company and not by the utility?
I'm not aware of that, and frankly, I don't know that it matters, because in New Mexico and in most states, goodwill is excluded from rates, and you know that's the case here. And I can't think of a jurisdiction where goodwill is included in rates. So so I'm not aware of anybody requiring what you're suggesting, but I'm also not sure it's entirely important or relevant, because we exclude the goodwill anyway. So it's and I've been through several acquisition cases here in New Mexico, and I know that that's a direction of this commission, and I know it's a direction of most commissions across the country, to ignore the goodwill, because it is part of this push down accounting, and it's related to the owner's acquisition of the company. It's really an investor. It's really tracking the investor's excess over book value that they're paying for the business. And so I don't know that I guess all I'm saying is I don't know that it's important that that would be the case.
It affects your balance sheet, is that correct?
Yes, our assets are higher by the amount of goodwill, and generally our equity is higher as well.
I have nothing further. Thank you very much, Mr. Shell.
Thank you.
Thank you, Ms. Beatles. Ms. Lynch or Mr. DeSalen, I believe the next cross-examination participant is CCAE, and I believe you've reserved 30 minutes.
Correct, hearing examiner Hurst. I'll be conducting the cross-examination of Mr. Shell, and
Very
I
well,
doubt
Ms.
that will
Lynch.
take the entire 30 minutes.
Go ahead, please.
Okay. Good morning, Mr. Shell.
Good morning, Ms. Lynch.
It's nice to see you again.
Yeah, it's great to see you.
Thanks. Could you please turn to joint applicants exhibit number 11, your rebuttal testimony?
Okay, I'm at my rebuttal.
Okay. And we'll be looking at pages 22 and 23.
Okay.
Starting at lines 21 on page 22.
Okay.
And there you state New Mexico Gas Company cannot limit and has not limited under Emera ownership, the expansion of its distribution system in pursuit of climate or greenhouse gas commitments, contrary to its obligation to serve both existing and future customers in a safe, reliable, and affordable manner. Do you see that?
I apologize. I'm assuming you read it right. I thought you were starting on 21, so that threw me off a bit, but I see you're starting on line 22.
Line 22 of page 22.
Yes, let me read this quickly. Okay, yes, I've read that.
Okay, and you stand by that?
Yes, we have an obligation to serve, so that would apply under Emera ownership or under any new ownership as well.
Okay, so my question for you is, do reductions in greenhouse gas emissions necessarily mean that the distribution system must be limited?
Could you state that again? I just want to make sure I understand the question.
Yes. Do reductions in greenhouse gas emissions necessarily mean that the distribution system must be limited on New Mexico Gas Company's utility system?
I apologize. I'm trying to get my head around that question, I guess. I hate to do this. Could you repeat it again? Because I'm just trying to understand the question.
Yes. Do reductions in greenhouse gas emissions mean that the distribution system that New Mexico Gas Company relies upon must be limited?
I guess the limited part is throwing me off, but no, I don't know that that's, well, I guess what do you mean by limited? I need to understand what you're
Does the
asking.
distribution system need to be limited in order for greenhouse gas emissions to occur through New Mexico Gas Company?
I'm assuming you're referring to expansion or not expansion of the system. Is that where you're getting at when you say limited?
Yes, I mean, can the system expand and the company could experience greenhouse gas emission reductions?
Yeah, I suppose there's scenarios where you can expand the system and reduce greenhouse gas emissions. You know, as a company, we're always working hard to reduce our emissions, and we've undertaken a number of programs over the years to reduce our emissions in the business, and that we have taken on those programs and those initiatives even while growing the business.
Okay, great. So my next question is, has New Mexico Gas Company explored whether greenhouse gas emission commitments are always contrary to serving existing and future customers in safe, reliable, and an affordable manner?
Could you repeat that again? It's a very I'm trying to piece together all the words there and just make sure
Has New Mexico Gas Company explored whether greenhouse gas reduction commitments are always contrary to serving both existing and future customers in safe, reliable, and affordable manners?
Have we explored whether greenhouse gas
Emission reductions
reductions
are always contrary
I don't know that contrary to what, I'm sorry.
to serving both existing and future customers in safe, reliable, and an affordable manner?
I don't know that. No, if I'm understanding your question, I don't believe that greenhouse gas reduction commitments are, as I would approach them, I would not approach them in a way that would impact the safe and reliable delivery of gas for current and future customers.
Okay. Those are my questions. Thank you, Hearing Examiner Hurst, and I appreciate your time, Mr. Shell.
Yes, thank you.
Thank you, Ms. Lynch. I believe the next cross-examiner is you, Mr. Freeman. And I believe you have reserved 90 minutes for Mr. Shell.
Yes, Your Honor. Thank you.
Please go ahead.
Morning, Mr. Shell. I don't believe we've ever met, so it's nice to meet you.
Yeah, it's great to meet you as well by Zoom.
Jelani Freeman, and I'm representing the federal executive agencies. Just wanted to ask you a couple questions to start off about your current and former roles. So when did you join the gas company?
My official start date would have been January, I believe, 30th of 2009.
And your current role now is president, is that correct?
Yes, it is.
What other positions have you held in your tenure with the company?
Yeah, so when I joined the company in January of 2009, I don't remember exactly what my title was, but it was like vice president, controller, and treasurer, I think is what it was. Upon my joining the company, I think it was later changed to vice president of finance and treasurer.
And can you explain to me, I guess, on a high level, those two vice president roles, what your primary duties were?
It was really to oversee all the finances of the company, really every aspect of the finances for the company, accounting, tax, raising capital, those sorts of things.
And so in the prior acquisition cases for the gas company, what was your role and how'd you support the company in those prior cases?
The prior acquisition cases?
Yes, sir.
Yeah. So in the acquisition case where TICO acquired our business, I was the vice president of finance at that time, so I would have testified in my role as a vice president of finance. And then in the acquisition, when Emera then bought TICO, I was the president of New Mexico Gas Company at that time, so I would have testified much the same way I'm testifying in this case, as the president of the company as the primary policy witness.
Great. And I guess the last few gas company rate cases, you've testified, at least on a high level, surrounding the company's rate design proposal. Is that correct?
Yes, I think as I introduced the case in my direct testimony, I would have talked about rate design at, again, a very, very high level because we actually hire a consultant to do all that work for us. So I probably would have mentioned rate design and essentially mentioned him as the primary witness to cover rate design in detail.
But in those cases, you've laid out what the proposal for the company in terms of rate design would be. Is that correct?
I think our consultant would have kind of laid all that out. I may have mentioned in the rate design something very high level, like a change in customer access fee or something like that. But I wouldn't have gotten into the details necessarily of rate design. I might have mentioned the access fee, as I said, for residential customers, because that's oftentimes something people want to know. So I may have mentioned that in my direct testimony.
Okay. Well, I guess where I'm going is it fair to say you have a general understanding of rate design?
Yes, I've actually not done rate design, but I would say as the president and as the former VP of finance for the company, I have a general understanding. If you want to get down into the weeds of different things, I probably am not going to be able to help you there, but I think at a high level, I generally understand what's trying to be accomplished through the rate design process.
Okay. Guess if we can just move on to your rebuttal testimony. And if we can go to page 2 and let me know when you're there.
Yes, I am there.
All right. And so on page 2 on lines 4 to 14, you testify that it's your understanding that FEA's rate allocation proposal is based on a volumetric calculation which had been utilized in the past by the commission. Is that a fair summary of those lines?
That is what I state in the first sentence, yes.
Okay, so when I asked Mr. Baudier to explain how volumetric usage allocation would work, he specifically deferred to you. So can you explain your understanding of how a volumetric allocation of the rate credits would work?
Yeah, there's different ways you could distribute rate credits. You could distribute them the way we're proposing in this case, which is on a customer basis, or you could distribute it in a number of different ways, I guess, that you choose. And I think you are referring to a prior case, specifically the case where TECO acquired New Mexico Gas Company, and we did in that case decide to allocate or pay the rate credit to customers using a volumetric calculation.
Okay, so again, I'll ask my question again. Can you explain how a volumetric allocation works in terms of what rate classes get what, or how is it calculated?
Okay, yeah, sorry if I wasn't responsive. So in trying to do a volumetric type of distribution of the rate credit, I could refer back to that case that I referenced, the TECO acquisition case of New Mexico Gas Company. In that case, what we did was we took the rate credits, and I think they were $4 million, and we would divide them amongst customer classes based on the last rate case, the revenue requirement in the last rate case for each of those customer classes. And then we would allocate the credit to those customer classes that way. And then within those customer classes, the credit was placed on customer bills based on the volume of gas that those customers used for the months that the credit was being applied.
So in what you just explained, there's sort of a two-step process. Is that correct?
That was my understanding of that case. You had to first kind of spread the $4 million to customer classes, and that was based on the last rate case and the allocation of the revenue requirement in that case to those classes. And then you're right, you then on the monthly bills, then that gets allocated based on the volume of gas used.
Okay. So I also asked Mr. Baudier during my questioning of him if any study or calculations were done to show the results of how the rate credits would be distributed through a volumetric usage allocation as opposed to per capita, which the joint applicants propose. And he said you may have better insight into that. Do you know if During the preparation of this case, that was looked at. Calculations were made, a study was done to see just how much each rate class would get under a volumetric rate allocation.
There wasn't a specific study done on that. Now, arguably, you could point to Dr. Erickson's study, where he takes into account the rate credits and the impact on the broader economy of rate credits going to customers. So, in some regard, he may have studied that from a pure economic perspective and how it impacted his study. Otherwise, I think I know I support what Mr. Bernhard. Mr. Bernhard's not testifying in this case. Mr. Baudier, I do support what he is proposing in this case. We believe that allocating the cost in the way we're doing it gets the most money into the pockets of our residential and small commercial customers, and we think that in theory, we think that'll have a better impact on the economy. I will point out too that in the 13 case, the rate credits were largely attributable to cost savings that were being projected in that case. We were moving to a shared service environment, and so the 4 million in rate credits were designed to get the cost savings that were projected to customers. And in that case, because there were identified cost savings, it seemed reasonable to apply those cost savings or credit them back to customers, similar to how we did it in our last rate case. And so that's why that exercise was undertaken. In the immediate case, the 22.4 million in rate credits is in my view is different than the 4 million in rate credits, because as I said, the 4 million related specifically to cost savings that were identified by the applicants in that case. And so in the immediate case, because the 22.4 million really aren't tied to anything anything specific to underlying costs in the business, it just felt like we should distribute that in a way that provided the greatest benefit to the state of New Mexico. And we felt that that money going to residential customers and small commercial customers made the most sense. For example, Mr. Friedman, our average residential bill is $44. So this $40 in credits going to residential customers is almost paying for one month of service for customers. So I think that's substantial, and I think that will impact the New Mexico economy in a positive way.
Thank you, sir. I think I'm having a problem with, you mentioned that there might have been something in Dr. Erickson's testimony or study. Would you happen to know where that might be? Because I don't know if I'm seeing what you referred to in his testimony.
Yeah, I think Dr. Erickson evaluated the impact of 20 new jobs, the impact of rate credits on the broader economy, and economic value or economic development type of funding. And so, if you want me to,
I'm sorry. Just in turn, I'm just focused on the rate credits.
Okay.
In this line of questioning. And I think my question, and maybe that's where the confusion is, I think my question was, did the joint applicants essentially like come up with a number? I know there's a number for the per customer per capita now with the 22.4, how that would be broken down, and that's pretty simple math. But wanted to know if that exercise of going through and your understanding of what a volumetric allocation would be per rate class, was there ever calculations done to determine what the numbers would be in that situation?
No, that's my testimony. We did not do something as you're describing it. I was trying to be all inclusive in my discussion there of studies, and Dr. Erickson did study the impact of the $15 million going to residential and small commercial customers.
Okay. Can we turn to the certification of stipulation in case number 13-00231?
Yes, we will.
Pardon me, Mr. Freeman, is there an exhibit number that we can use to pull up?
I believe it was in an area exhibit number 43. It was administrative notice was taken of it.
Thank you, sir.
Thank you.
And I want to direct you to page 29. So if you could just let me know once you're there.
Okay, I'm on page 29.
So if you look at the last paragraph on page 29, starting with the bill credits, can you read for the record those first two sentences in that paragraph?
The one that starts the bill credits.
Yes, sir.
The bill credits would be allocated to each rate class in proportion to the revenue requirement for each rate class from NMGC's last general rate case, case number 11-00042-UT. You want me to read the next one?
Yes.
Okay. The residential and small volume general service rate classes would together receive 94.6% of the bill credits.
Okay, and then just going to the next page, with the first full paragraph, starting with after, is what I'm wanting to make sure is that what you described as volumetric allocation is what we're seeing here. So if you could just read that paragraph, it's only one sentence.
You want me to read it into the record or just read it to myself?
Yeah, yes, sir.
After bill credits are allocated to each rate class in proportion to the revenue requirement for each rate class, credits within each rate class would be distributed on a volumetric basis, meaning the customers who use larger amounts of gas would receive larger rate reductions. And it refers to the Ms. Crane's stipulation testimony.
And so is that again your understanding of how volumetric allocation of rate credits works, the way it's explained there, where you just read into the record?
Yes, that would be the same across each rate class, including residential. So in that case, larger users of gas, even at the residential level, got larger rate credits. So what we're proposing in this case is that everybody get the same rate credit. And so in that case, people who used less gas, smaller homes, would get a smaller rate credit.
And from that last case, it's correct that the overwhelming majority, which I believe is 94.6% of the bill credits, went to residential and small volume general service rate classes, correct?
That is what is referenced on page 29, yes.
And so I just want to, I think you've, I guess maybe sort of used, I guess a different wording that is sometimes used in terms of this allocation step, but
Is
I
that
just want to. I'm sorry, take a
okay?
pause. I just want to make sure for the record, because again, when questioning Mr. Bodier about this, I thought there might be some confusion. So I just want to make sure for the record that you agree that this allocation method, as you just read into the record, is not the same as simply looking at customer volume cells and allocating based on those volume cells, correct?
No, as we discussed, it's a two-step process, and I think this final order describes it very accurately. This is what I was attempting to describe to you in my testimony. So hopefully I described it this way. I think I did, but maybe I used different words. And but this is in fact how it was done in that case.
Yeah. No, I think what happened is you just endorsed what Mr. Bodier's testimony said, and I think Mr. Bodier may have confused some things, because I think one of the things he said is that
Can't testify, Mr. Freeman.
okay. Um, so in your opinion, do you think in this 13 case, the commission allocated the rate credits in a reasonable, fair, and equitable manner?
In my opinion, based on the facts of that case and the fact that these rate credits were in fact related to anticipated reduction in cost, that this allocation or the allocation method we used in that case was an appropriate allocation method under the facts and circumstances of that particular case.
Can I get you to go all the way down to page 82, which are the decreto paragraphs.
It's a long document. There we go. I'm on 82.
And so looking at decreto paragraph C, is it correct that that paragraph is directing the gas company to file an advice notice containing the per therm rates? And I believe
Containing the per therm rate?
An advice notice containing the per therm rates.
Thank you.
In what is referred to as JA Exhibit JMF 3 STIP, necessary to implement the bill credits.
Yes,
that
I'm
correct,
reading the first couple lines there, and that is what's being indicated. I think you're characterizing it accurately.
Okay. So it'd be great if we could actually go to where that exhibit comes from. Can you turn to what's labeled, I guess, in the Dropbox as FEA exhibit number 5? This is the exhibits in support of stipulation of John M. Fernald.
Yes, just give us a moment, please.
Sure.
We have a great group of regulatory staff here at the gas company who keeps us on track and helps us
Can you spell that witness name, John M?
Fernald, Fernald.
Thank you.
And you asked me to go to one of his exhibits, is that accurate?
Yes, the exhibit that was just referenced in the stipulation, that's should be exhibit 3. And this is not as long of a document as the other one.
Yep, I'm on JA exhibit JMF-3 STIP.
Okay, so I just want to focus on the first chart, which says first year, just for a second here. And so this, the title of this exhibit is Benefit to Customers of Bill Credits During Rate Freeze Period. Is that correct?
Yes.
Yeah. And I know it was, well, strike that. So it looks like in the first year, the bill credits total just 2 million. Is that correct? Do you see that?
Objection.
What's your objection, Mr. Haverly?
Relevance, Madam Hearing Examiner. This is a rate design of a case 14 years ago, sponsored by, well, I have 2, I guess. So 14 years ago, revolving figures that are not currently in the record here for any purpose. I'd also object based on the fact that this was created by an individual who is not here, cannot testify about any of this and the accuracy of any of this information. So I have a foundation argument as well as that there, and a fact that this has not been there's nothing to authenticate this other than it was filed in that case. So I have 2 objections: relevance and the fact that this is earned by somebody that is not here testifying today.
Mr. Freeman?
Yeah, so I think first off, I laid the foundation that in Decreto paragraph C of the stipulation, this very same exhibit was referred to and was directed by the company to use and to implement the bill credits under the stipulation. And so there's a couple more parts to it too. The other part is this is what was used to implement the bill credits in that case, and it's not written testimony at all, even though I have another argument for that. It's just the plain and simple numbers that the stipulation required to be implemented.
And then as far as the second part of the argument, which had to do with the fact that the testimony that you have as your exhibit was part of a case and that witness is not here and able to be questioned upon that testimony.
Madam Hearing Examiner, in FEA's direct testimony, we cited this testimony and these exhibits on pages 6 and 13, footnotes, and Mr. Baudier in his rebuttal specifically responds to that testimony, essentially saying that he looked at what was done in this case and disagreed. And then Mr. Shell backed up Mr. Baudier's testimony. So the other part of it is, in this case, there was a status conference that was held, and there's a following revised procedural order setting schedule to consider stipulation. Both staff and interveners noted that they did not want a hearing to consider the stipulation, and all parties waived their right explicitly to cross-examination of the testimony in support of the stipulation in that case.
So what's the import of that?
I guess the importance of that is that even though Mr. Fernald is not here, that to be, I guess, cross-examined about this testimony, which I'm not even trying to get the testimony, and I'm just looking at what this stipulation directed for the exhibit with the rate credits. But regardless of that, I think with the waiving of that cross-examination, that bolsters that we should be able to question Mr. Shell about this.
So you're not asking, you're using this as a cross-examination exhibit. You're not going to try to introduce the exhibit.
I believe this exhibit, in terms of the exhibits attached to the testimony, I was planning to ask the hearing examiners to take administrative notice. And again, specifically because if you look at the certification stipulation, it was those exhibits from Mr. Fernald were relied on to build out the case of how to allocate the rate credits.
Well, there's a lot of testimony in that certification and stipulation that was relied upon by the hearing examiner to issue that certification of stipulation. Right?
But this specific one was in the decreto paragraphs, and as I just laid the foundation before we came to it, it was required that the company go to this exhibit of Mr. Fernald and use it to implement the bill credits.
Okay. Anything further on that, sir?
No.
Any response to that, Mr. Haverly?
Madam Hearing Examiner, there's a lot of information in this exhibit that frankly, I continue to wonder what the relevance is about the number of bills being issued, customer counts in 2014. There's lots and lots of information here that I do not believe that there's any relevance to this case. If Mr. Freeman is trying to prove that there was some type of volumetric charge, we've already covered that ground. And I continue to object to the admission or even discussion of this document while it was referenced. it was not adopted or attached, Madam Hearing Examiner.
Okay, I'll go ahead and, I'm gonna take it under advisement. I believe we're going to break, for our luncheon hour, at this point.
That's what I see.
And, it is, 5 after 12, so I think if we come back at 1:05, and I believe Mr. Freeman, I just turned off the clock. I believe you had 54 minutes remaining. All right, it looks like I've got some people raising their hands. What? I think Mr. Harris, you had your hand up first.
Yes, Madam Hearing Examiner. I just, I have not practiced a lot in front of the PRC for the past 10 years, but in previous years, I've noticed that most exhibits, most testimony is allowed in and accorded the weight that it merits. And that it's important to remember that the rules of evidence are specifically not applied here. I know that we use it as a template to help organize the hearings, but I would urge that they not be weaponized. Thank you.
Thank you, Mr. Harris. Ms. Nanasi?
Yes, thank you, Madam Hearing Examiner. I just wanted to get an idea about what your plan is for the afternoon, excuse me. I have to leave at the end of the day, and so I wanted to know if we can discuss after this witnesses is done, perhaps we could know, first of all, who the next witnesses are, but second of all, if we could discuss new energy economies exhibits and also the issue that Mr. Alvidrez raised for in between this witness and the next witness. Also, I wanted to get your idea about what you're thinking about a schedule for next week's witnesses, because I wanted to give you an update about my witnesses' availability. So that's what I'm raising.
Okay, so more procedural matters to be discussed this afternoon.
Yes.
Okay, did I see? Okay. Did I see one more hand?
Yes, Madam Hearing Examiner, Joseph Yar.
Mr. Yar.
I just wanted to let you and Mr. Schaefer know that NMary is waiving its cross of Ms. Kelly.
Okay, you had 30 minutes. Mr. Yar?
Yes, ma'am.
Okay, and now 0.
Yes, ma'am.
Okay, thank you. Okay, any other procedural matters? Now we're at 12:10, so we'll come back at 1:10, and remember the YouTube's on, and you may want to mute your screen if you're staying on the Zoom. Okay, thank you. We are recessed for Mr. Lee,
I'm ready, Judge.
very well. Thank you, sir. We're back from our luncheon recess. Parties can be informed that I was productive. I found out how to get myself off the share screen. And I found out that you don't need an index card to put over the camera, that there's actually a stop video button. Things are on the upswing.
Madam Hearing Examiner, I saw you putting that that paper on the camera, and I thought that was an extra precaution, and I was thinking maybe I should follow your lead.
I was trying to block the camera while I ate my lunch.
It's the shortest way though, right? So
Yeah. Well, thanks to Phil and IT. And I think this might be an appropriate moment actually for me to acknowledge that there's a whole lot of people that help all of us here participating in the hearing to get to do our jobs. And so I'd like to acknowledge all those people that in our employment and in our personal lives that help these hearings happen. So thank you. Couldn't do this without you. I think at this point in time, we do have some procedural issues, but I think those can be handled later this afternoon. But right now, we have a pending objection to a question posed by Mr. Freeman with regard to an exhibit, testimony exhibit, and questions about that testimony exhibit in commission case number 13-00321. And that has been referred to as the TICO case. And this was the TICO Energy acquisition of New Mexico gas. And upon consideration of the arguments and the commission's, what I believe to be the commission's policy, I can tell you it's my policy. Testimony from other cases where the witness is not available or has provided testimony in this particular case violates the right of confrontation in that not only is the information not necessarily verified and or relevance established in the current case, but no one has an opportunity to cross-examine the witness. Therefore, since Mr. Fernald is not in this case, his testimony from case number 13-00231 uh, will not be admitted in this case. And in addition, with regard to the particular question, I don't believe the relevance has been established that Mr. Shell has the requisite knowledge to be even cross-examined on any chart that the commission might have utilized in its certification of stipulation in this case. Therefore, your objection is sustained, Mr. Haverly, and I will go back and start the timer. Mr. Freeman, I think I indicated when we broke for lunch that I believe you have 54 minutes left, sir.
Madam Examiner, can I ask a question for clarification?
Yes.
So I understand that Mr. Fernald's testimony cannot be used here. And I heard you in terms of also using the chart, but in the stipulation, at the very end of the stipulation, one of Mr. Fernald's exhibits is attached to the stipulation. Are you saying that FEA also cannot use that exhibit that's attached to the stipulation?
Hang on 1 second for me, Mr. Freeman. To the extent, Mr. Freeman, that Mr. Shell is familiar with the certification and that exhibit, I think you can ask him a question on it. Does that clarify?
Yes, it does. Thank you.
Okay, I'm going to start your time back. And like I say, I think you have 54 minutes, sir.
Thank you. Mr. Shell, can I direct your attention back to the certification of stipulation in 13-00231?
Is that this one? Yes, I have it here.
If you could go to page 82 of the stipulation, if you're looking at it online, I believe it's PDF page 89.
Did you say 82?
Yes, page 82. It should be
Yes, I'm on page 82.
There's a footnote number 34 at the bottom of that page. Can you read that footnote for me?
JA Exhibit JMF-3 STIP is attached, or I'm sorry, is attachment C to the certification of stipulation. The first year per therm rates for each rate class appear in the column entitled per therm under bill credit per customer class.
Are you familiar with this exhibit?
Well, I probably haven't looked at it since 2014, but I can scroll here to find it. It is attached to this document.
Yeah, it's probably 2 pages from the end. If you don't mind.
It looks like there's different exhibits attached. You have the PDF number? Page
the PDF number I have is 109.
Okay, thank you. Okay, I'm there. Attachment C.
If you wouldn't mind, if you could just look it over for a second, I just had maybe just a couple questions on a very high level to ask you about the exhibit.
All right, looks very similar to the exhibit you were showing me before, so I'm semi-familiar with it from our discussion earlier.
So I wanted to direct your attention to the top table in attachment C, and specifically column 6, below the label per therm and under the label bill credit per customer class.
Yes, I see that.
Would you agree with me that column 6 shows the first year rate credits approved by the commission?
The first column? Is that what you referred to?
Column 6.
Column 6, I'm sorry.
What's it entitled?
Bill credits per customer class, and then
Yes.
per therm.
Before the lunch break, did you previously state that the first step in deriving the rate credits shown in column 6 in that attachment was to allocate the dollar amount of the rate credits to the rate classes?
Yeah, I think my testimony that was my recollection from this case. And when I mean this case, the TICO acquisition case.
And I think previously we agreed before the break that the dollar amount of the rate credits were allocated to the rate classes based upon the base revenues resulting from the prior general rate case. Is that correct?
That is my recollection. Yes, that would be my memory from 2014, is that We allocated it, the credits based on each customer class, their share of the revenue requirement from the prior rate case.
And based on your recollection, that was that general rate case number 11-00042.
Yes, it's referenced in the exhibit you're referring to here.
And now directing your attention to column 5 in this top table of the attachment, and it's labeled, the column is labeled annual under the label bill credit per customers. Do you see that column?
Yes.
And so would you agree with me that column 5 shows the allocation of the first year rate credits to the rate classes, and that totals $2 million?
That appears to be what's going on in the exhibit.
Would you agree with me that the class by class dollar value of the rate credits results from the allocation to the rate classes based upon that previous case 11-00042?
That is my recollection, and I believe that's what we read earlier. If we scroll up in this document, I think that's what was referenced in the order.
All right. So would you agree with me, looking at column 5, that column 5 shows the results of the allocation process, not the second step that involves developing the per therm or volumetric bill credit for each rate class?
I apologize, sir. Can you say that again?
I was asking if you would agree with me that when looking at column 5, that column shows the results of the allocation process and not the second step that involves developing a per therm / volumetric bill credit for each rate class.
Yeah, I don't think I can verify that with the information in this exhibit, but my assumption is that is what is happening in that column.
Okay. And so just wrapping up this line of questioning, getting to that second step that we talked about before lunch of the process of calculating the bill credits, would you agree that column 6 is simply column 5, the class by class dollar amounts of the rate credit divided by column 4, the class specific therm volumes for each rate class?
Yeah, I don't see that there's a footnote indicating that, and I don't have a calculator here to run a check, but looking at the table, I could conclude, but can't verify that that's what's going on there.
Okay. And just to put a pin on it, column 4 that you're looking at, the class by class therm volumes, were not used in step 1 to allocate the dollar amount of the rate credit that is $2 million to the rate classes, correct?
Yeah, that would be my recollection of how this process occurred in 2014. It probably states in the commission order somewhere up above in this document.
Thank you, Mr. Shell. I have no further questions.
Thank you. And Mr. Freeman, let me apologize. I think before the lunch break, I referred to you as Mr. Friedman at one point, so I apologize for mispronouncing your name.
Thank you for that.
Mr. Freeman, this is your last question on this area or totally?
Totally, Madam Hearing Examiner.
Very well. Let us go on then to the cross-examination time allocated by staff. Staff requested, I believe, 90 minutes for cross-examination.
Yes, ma'am, we did.
Miss Lang, are you gonna do the cross for this witness?
That is me.
Okay, go ahead, please.
Thank you. Good afternoon, Mr. Shaw. Nice to see you again.
Good afternoon, Miss Lang. Great to see you.
So keeping in the spirit of everyone asking you about the shared surfaces, I too have to ask you about it. Sorry, I wanted to maybe ask you something more novel and fun, but alas. So we were wondering if is NMGC intending to train all the New Mexico-based staff on the new intended Oracle systems?
Yeah, if the excuse me, if the acquisition is approved, we'd have to hire those individuals, and some of them may come with Oracle knowledge. I don't know what the situation might be, but those that don't would potentially need to be trained on the system, depending on the level of use that they may have in the system.
So whether or not a New Mexico-based staff would be fully trained I guess it would be fair to say it's TBD. Is that correct?
Yeah, it is. We're going to hire those. Are you talking about the 20? I'm sorry, let me back up. Are you
Yes,
talking about the 20 new people? Yeah. So, when we post for those positions, we may ask for folks with Oracle experience. So it would be very nice if we got a whole bunch of people that had Oracle experience, and then we wouldn't have to train them necessarily. So, but the chance of that happening with all 20 is probably not 100%. So there's probably some training going on.
Okay. Can you tell us what the shared surface budget is for, if not 2025 and or 2026?
Yeah, so I don't know if I know the budget for 25. I was actually just talking to my vice president of finance here in the last couple of days because there's been a lot of questions around this. So he indicated that the forecast for 25, because we're still in the midst of 25, was 12.4 million. And for 2026, we're still working through the budgeting process for 2026. So not yet finalized, but he was saying he thought it was going to be in the range of 12.7 to 12.8 million.
So closer to 13. Okay.
Ms. Lang, I want to caution you to not comment on the witness's testimony, okay?
Sorry,
You can't.
Yes, I apologize. I have more questions about the shared services, but this got me thinking. The upgrade for the currently existing SAP system was it 56 million? An estimated amount?
The upgrade, well, there's two upgrades that need to occur. There's the SAP system, and let me hear, I want to make sure I give you accurate numbers. I have that written down here somewhere. The upgrade to the SAP system would be about 24 million overall, and the upgrade to the asset suite system and some ancillary systems that work with that system would be about 32 million. So the total is 56 million.
Is it the case that the 24 million upgrade can't function without the 32 million upgrade?
I don't think that that's the case because these are two separate systems. So I think they can be done independently of one another.
Why would you choose to spend the 32 then, in addition to the 24?
Because our asset suite system is essentially at the end of its life as well, and has not been a great system for us with the mega rule that came out from PHMSA. Which requires a significant amount of tracking of pipeline assets. And so our engineers and operations folks have struggled with the systems we currently have to comply with our regulatory requirements under the mega rule. So we are embarking on a plan to completely update that and change that system so that we're better able to comply with our compliance requirements.
When did you get the price tag?
I guess I wouldn't know the answer to that. I think it's been in our 5-year forecast for, well, I guess I don't know. It's been something that's been talked about in the business for a couple of years, and I don't know if that number has ebbed and flowed over the last couple of years or not, but I know the most recent estimates from our IT staff is 32 million.
I guess, if this acquisition was not taking place, would NMGC would you guys have stayed with I guess would you have coughed up the 56 million upgrade anyways?
Yes, that's the current plan, and our current 5-year forecast is to upgrade the asset suite system. I call it generally asset suites, but it's like 4 or 5 different systems. We would upgrade that and modernize that, and we would also upgrade the SAP system. That's the plan. That system, the SAP system, is a shared system with Tampa Electric and Peoples Gas, so we're intending to work with them to upgrade that system.
And that's the server-based one, right?
They are both currently server-based right now.
Would the 24 million buy you a cloud base with SAP, or would you still be?
Yeah, I don't know that we know the costs. There's been some discussion in this case about the fact that SAP has, I believe, recently announced that they're going to be coming out with some form of cloud-based system. I think Mr. Miko talked about that. So at the time we did these estimates, we didn't even know that the cloud-based system was an option. We may have known it was coming, or some of my IT folks may have known it was coming, but the estimate was based on the server-based SAP system.
Isn't it true that and I can't remember who, it's been a really long week. In your somebody cross-examined you about the SAP system losing like potentially like back system support. Is that true for the server system?
Yes, I think Mr. Miko and Mr. Tuminello spoke to that. I've talked to my staff about that too. Yes, I believe right now SAP is saying they're no longer, as an organization, supporting the version of SAP that we're on. I think they're gonna support it and provide support through the end of 2027.
So I guess my question is, knowing that, why would you have still considered staying with the $56 million total upgrade anyway, knowing that in 2027 you might have to spend more money to upgrade again?
Oh, no, what we would be doing is actually upgrading to a version of SAP that is supported. So the version we're on is, I'm not entirely sure I know the exact years, but TICO launched this system somewhere in the neighborhood of 2005. So it's a 20-year-old system. And so SAP is basically saying, we're no longer supporting this version. If you still want to stay with SAP, you need to upgrade to something more modern that we can support.
And would the 24 million buy you that upgrade?
That's the estimate that TICO came up with. That would be our share of the total cost of that system.
Okay.
That's an estimate that was put together by, I said TICO, but I meant Tampa Electric.
Thank you for that. I have a question about capping the cost of the shared services, which is something staff has been trying to get an answer on. So in our process, both Mr. Baudier and Mr. Terminello, we asked them if NMGC could, or BCP alternately, could commit to capping the cost of the shared services to 12 million per annum. And we did not get that commitment. And so seeing that of all the witnesses from the joint applicants here, you're the biggest cheese, I guess we're going to ask again if we can get a commitment that you will cap the total costs for the shared services as 12 million per year.
Yeah, I think the joint applicant's position on that is we're worried about the inflationary impact on that number. So while in our last rate case, the number was under 12 million, it is now well in excess of 12 million under the status quo. And even under BCP ownership, that annual cost will increase just like it will under Emera ownership. So we're not inclined to agree to a cap. But again, in the next rate case, we will have to show that any expenses we're incurring are reasonable expenses for the business.
I'm glad you brought that up. I would like for you, please, to pull up staff exhibit, what has been labeled as staff exhibit number 5.
Okay.
And it's around page 30 in the PDF. It's an exhibit that's labeled NAV1.
All right, I think I am there. It looks like NAV 1 page. What is this? 2 pages, it looks like. Am I at the right
Yeah.
one?
Yes, it is the joint applicant's response to New Energy Economy second set of interrogatories. Okay, so if you go to page 2 of 5,
Okay.
you will see at the table, it's kind of faintly highlighted in yellow. The shared services cost totaled 10 million and change for 2023 as it stands currently.
Oh, down here.
Yeah, the bottom of column for 2023.
Yeah, I'm seeing the number you're referring to.
Okay, and if you go to the next page, which is page 3 of 5, the second table.
I'm sorry. The next table, is that what you said?
The next page, page 3. If you go to the next page. Do you have page 3 of 5 for staff exhibit NAV1?
No, I don't seem to. I'm on something that's page 1 of 2 and 2 of 2. And then the next page is.
It's possible you have the unupdated version.
Okay.
If I were to tell you that page 3 of 5 of staff exhibit NAV1 shows the total shared services expense for 2024 was over 13 million, would you be surprised?
All right, I need to get myself grounded here. I'm still on NAV1 page 2 of 2, and there's a $13 million number. Is that the number you're talking about?
Yes.
Okay.
So on the page 3 that I have, it says the increase is primarily due to labor, benefits, and capital expenditure.
I apologize. I'm not finding what you're referring to. Just a minute, we're trying to.
Okay. Which interrogatory response?
This is interrogatory response, NEE interrogatory 2-5.
So is this what I'm supposed to do? I'm looking at. You're correct. Oh, I think I just found it. It's attached to someone's testimony, it looks like.
Yes, correct.
Okay, all right, we found it, okay.
Yes. It's under the heading total shared services expenses. Mm.
And you're on page 3 of 5, is that where you're at?
Yes.
Okay, I'm sorry, I'm here now, thank you.
That's okay, excellent.
Thanks for your patience.
Oh, no, I'm sorry, this was a maze, but, okay, so under the table under the heading total shared services expenses, the rightmost column, total column is over 13 million. Do you see that?
I do.
Okay, and in the print and explaining this, it says the increase is primarily due to labor, comma, benefits and capital spend.
I see that.
Okay, what happened to labor benefits and capital expenditures that led to the increase?
Well, this is coming through shared services, so I think it's just the folks in Florida and in Nova Scotia who provide these shared services, their wages are rising, just like the wages here in New Mexico. And so that would account for the increase in labor and benefits. The capital spending that I see there, I don't know if I should speculate or not. I would, I'm speculating that some of our shared IT costs that come through from Florida for patches and upgrades, not necessarily upgrades, minor changes and upgrades to the SAP system, based on my knowledge of what charges come through from Florida. And so the reason those might go up is there's more, they've done some additional patches or they've done some additional work on SAP to get to be able to use the system.
Was this a foreseeable increase in expenditure? Can you tell?
Well, what do you mean by, was it a
I
foreseeable?
mean, did you guys anticipate this increase in 3 million?
I guess I think we're talking about different things here. I'm not sure where this table comes from, but I do know. So when you say an increase by 3 million, what are you comparing the 13.2 back to?
To page 2, the 10 million.
Page 2. 23.
For 2023.
Oh, so on page 2 of 5, that is just the shared service cost and not capital. And so when you scroll down here to page 3 of 5, that would equate to the column that says subtotal of expenses. So it's we're for 20, and again, I have to get grounded here. This is 2024, you're saying?
Correct.
Yes. So yes, I believe the 11.2 number on page 3 of 5 equates back to roughly the 10.765 number on page 2 of 5. So in other words, page 2 of 5 doesn't include capital. It's just true shared service expenses that would go to operating expenses.
Okay, that clears that up. I have another question. Earlier, I think when you were responding to NEE, you said your finance team was working on a forecast. I think it was vis-a-vis the upcoming rate case. Did I hear that correctly?
Yes, they are. Well, we have our forecast. That's a normal process we go through. I think what I was referring to, if I'm remembering the discussion with Ms. Manassi, was the fact that the team is upgrading, or not upgrading, is updating schedules so that it'll become very easy to file our 630 schedules when we do decide to file a rate case. In other words, they're going through a process where they're keeping track of the information that goes into 630 schedules. And as soon as we close out a month, they add that month to the 630 schedule work papers and take off the month 13 month earlier. So they're just kind of keeping a rolling 630 schedule is how I would describe it.
Okay. Is that a new endeavor? Or do you guys always do that?
No, that's something new that the finance team is just basically, we have a very unusual situation here where we need to file a rate case, but we don't know when we're going to file a rate case. So we're trying to make sure that we have done all the proper planning so that when we get to a point where we are going to file the rate case, we'll have a lot of that pre-planning work out of the way, and it'll allow us to file the rate case quicker.
So when did you start that forecasting process, which I'm assuming is not done yet?
No, it's an ongoing process. I'd have to talk with my vice president of finance to find out exactly when they began that endeavor. But I think it's been it began, I believe, in the last 6 months.
Okay, I'm gonna, because I'm a little confused, but you cleared up my confusion just now with something else. So I'm hoping you will do it here too. I'm going to direct you to what is labeled as NM Area Exhibit 10. Let me know when you get there, please.
They don't let me run the computer here. I would be so slow, we'd never get anything done. So I got my team back here helping me.
Hey, I wish I had that kind of problem. And well, actually, no, I don't, because I have nobody. So never mind.
Thank you. All right, I think I have this is NM Area Exhibit number 10.
Yes, page 14.
Is that the actual page number of the document or the PDF?
It's on the paper.
All right.
It's for interrogatory 6-4.
Yes.
So the question B, little b, I guess they're asking for the total cost and, you know what? I'm not going to read it. Could you read the question B into the record, please?
The question?
Yes, please.
Total cost increases in other categories, including labor, pension, goods and services, litigation cost, regulatory compliance cost, and other major cost categories.
Okay, so could you go to the next page, which is page 15, and read your answer into the record, please?
NMGC does not have forecasted cost in the categories requested above. Furthermore, references to increases provided in the question is unclear, as a comparative point to calculate such changes are not specified. In an effort to be responsive, NMGC has provided a comparison of forecasted operating expenses from its
I'm
2020.
sorry, sir. In an effort to be responsive, NMGC, and slow down.
Yes, I apologize, Mr. Lee. Where was I at?
In an effort to be responsive, NMGC.
NMGC has provided a comparison of forecasted operating cost from its 2025 LTF to the major categories of operating expenses provided in the 2023 rate case for calendar year 2027. Please see table 6.4b.
So when forecasting, do you guys not include the categories that labor and benefits, that the 3 categories that we just saw an increase in?
I guess I don't know that level of detail on the labor. So you're asking if we forecast labor?
Right, because the question was, can you tell us, what the forecast is for the 3 categories that we saw an increase in? And I guess you guys been doing forecasting for the past 6 months, but it doesn't seem like you have the data. So I'm assuming, which leads me to think that when you do the forecast, you don't take into consideration maybe increased costs in personnel and cap expenditures?
Objection, Brian Haverly, Madam Hearing Examiner.
Yes, sir.
I believe that was argumentative and testifying on behalf of counsel. I'd ask that that question be stricken. And for the rule of completeness, I think that we should read the full question that B is attached to.
Play.
I don't disagree with reading the entire questions. I was just trying to save time, but if we need to do that, I'm okay with that. I don't, I would obviously disagree that that was argumentative. I was just trying to formulate a question that included the categories, but I can rephrase.
Why don't we do that? And why don't we read the full question? Read the full interrogatory question before you rephrase your question. Okay,
Yes, ma'am. Sounds good.
go ahead. You're gonna read it in the record or have the witness read it?
I would like the witness to read it, please, if that's okay.
Mr. Show, would you please read the whole first part of the question for NM area interrogatory 6-4?
So 6-4 says, Mr. Shell testified that NMGC's agreement to delay its next rate case filing until September 26 would have a conservative value of approximately 30 to 40 million. Shell revised direct, page 22. That's the reference. Then it goes on to say, please provide the best estimate of the following categories of cost for the following categories of costs NMGC would be seeking to recover if it were to file for new rates in December 2026.
Okay, go ahead, Ms. Lang.
Thank you. All right, I will rephrase my question. Here it is. When forecasting, are the categories labor, benefits, and cap expenditures not included?
Yeah, I think in our forecasting, we do forecast in broad categories like total O&M and total taxes other than income taxes and those sorts of things. So that's how we would do our forecasting.
I guess I don't understand. So that's a no?
Correct. And when we do our 5-year forecast, we do not get down to that granular level of detail. We do it in broader categories.
I see. Well, you cleared it up for me again. Madam Mayor.
I'm sorry, Miss Lang, please refrain from commenting on the responses of the witnesses. Just limit your
Yes, I apologize.
examination to questions.
I apologize. Thank you. Madam Hearing Examiner, I would like to move what is this? Let me get my notes here. Okay, shifting gears now. I am going to ask you to take a look at what has been marked as Joint Applicants Exhibit number 11, which is your revised.
My revised direct or
revised application rebuttal testimony.
okay.
And then.
Okay, I actually have a paper copy of that, so I have it in front of me.
Excellent. Now. If you could go to page 13, please.
Yes, I'm there.
Could you go to line 11 and read into the record from line 11 to the first part of line 13 where it ends in volatility.
Since this is responsive to a question, should I read the question?
Yes.
Okay, all right. And I apologize, I don't know how to pronounce this person's name, but it's
Zadalis.
What's that?
Zadalis.
Zadalis, okay. Staff witness Zadalis proposes the creation of a severe weather fund in connection with the instant acquisition, a fund that staff believes will offer durable long-term benefits to NMGC's customers. DeSalis direct testimony at page 3 line 7 through 10. What is your response? My response is, I do not believe a SWF is necessary. NMGC's purchase gas adjustment clause tariff and its hedging program have successfully shielded customers from extreme weather related gas price volatility.
Thank you. Could you, for the record, could you tell us what the hedging program is?
Yeah, so it was something that was established in the late 1990s, where the commission recommended that we have a hedging program in place that essentially hedges our base gas. So in other words, we enter into hedge agreements and they can come in a variety of different forms, and I'm probably not the right person to talk about the different forms of hedging, but essentially we try to enter into hedges that allow us to hedge against price increases for our natural gas that we purchase for customers.
I heard you say base gas. What's that?
Yeah, so the hedge program is generally centered around our base gas, which is every month during the winter heating season, we have a level of gas that we know we're going to buy just based on history, just based on what normal weather would be during those months. So we hedge that base gas because we know we're purchasing it every day. The other types of gas purchases we would have would be, and there's probably several, but what comes to mind for me is swing gas. So if base gas doesn't, if it's a cold day and base gas doesn't cover the amount of gas we need to purchase for customers, then we will enter the market and buy swing gas, or we will pull gas from storage.
This hedging program does not cover swing gas, correct?
I'm sorry, swing gas?
Yes, like the dance.
Thank you.
Yes, it does not. We've not over many decades of doing this have not found an economic way to hedge our swing gas.
Could you also share with us what your conception of successfully shielded customers in extreme weather means?
Mm-hmm. Yeah, so and I think I may reference it here in my testimony. I refer to a situation on page 14 of my testimony where the hedging program resulted in around 100 million in costs from contractual counterparties, and thus shielded customers from price spikes. So that was just in January 2023, I believe. So over the course of the last 20, 30, 40 years, there have been instances where a hedging program has provided significant benefits to our customers in reduced gas costs. Yeah, so basically the hedges, we may go through a winter where they don't necessarily, they always provide a benefit because it protects us against these kind of price spikes, but we don't always get the results that you're seeing for 2023, where it actually saved customers $100 million compared to what cost would have been if we didn't have those hedges in place.
Why was 2023 a big deal?
I think it indicates there in my testimony on line 4 that in January 2023, the San Juan index pricing for our base load increased by a multiple of 8 to 9 times what the price had been a few days before, and it stayed high for multiple days. So our base load is set up on first of the month pricing, it's called IFERC pricing. And if the prices spike right around the beginning of the month, when the contractual terms for our base load are being set, it can cause us to incur significant gas costs for that month. So our hedging program is in place to prevent that very thing, and that's what it did in January 2023.
Well, it looks like you already are. Could you go to page 14 of your
Yes.
Yes. And do you see line 10?
Yes, I do.
Could you please read into the record line 10 to 11 where it ends at very rare?
Sure. We know that I'm sorry, let me back up. We know that price spikes can occur during times of extremely high gas demand, such as occurred during Winter Storm Uri in February 2021, but this is very rare.
Thank you. And then if we go to the next page, page 15, if you could read into the record, starting at the line 2, but it's like towards the end, but it starts at in fact. And if you could read till the end of line 4, please.
Yeah, I can. I don't know if we need to read this in response to the question or.
Yeah, well, let's do that.
Okay. How often in your experience are these storm-related gas price spikes? I'll just read the whole answer if you don't mind, just so it's clear.
No, go for it, yes.
While gas prices routinely fluctuate with the market, in my experience at NMGC, instances of gas prices increasing many multiples over a few days has been exceedingly rare. In fact, there has only been one instance in my 16 years at NMGC that required the company to take extraordinary measures, and that was Winter Storm Uri.
16 years. So you started in 2009?
Yes.
Would it surprise you, sir, that in the years prior to your starting at New Mexico Gas, there were 3 winter storms that affected gas prices?
It's my understanding that in the late 1990s, there was a situation where prices did spike, and that was the primary reason for the hedging program being put in place.
No, I'm talking about 2002, 3, and 7. Does that surprise you?
I'm not aware of significant price spikes during those periods. I wasn't here, so I'm not aware.
Would it surprise you, sir, that in the years following your commencement at NMGC in 2009 and before Uri, there were 4 winter storms as well that affected gas prices?
Well, let me just back up to understand what you're referring to as a gas price spike. Winter Storm Uri was rather rare, with prices spiking to hundreds of dollars per MMBTU, relative to where they had been trading at $2. So I do know that you do see prices fluctuate up and down all the time in this business, but generally, in my experience, the PJC has the flexibility to allow us to spread those costs over several months. So I guess I have to understand what you mean by price spike, I guess, or significant price spike.
Well, would it surprise you, sir, if I told you in the 4 winter storms that occurred before Uri in 2014, we had a cold polar vortex, and the Henry Hub BTU went up to $7.92. Would that surprise you?
Went up to what?
$7.92 per MMBTU, whatever that means.
Objection, Brian Haberly.
Mr. Haverly?
Assumes facts, not in evidence, Madam Hearing Examiner. There's nothing in the record about any of this stuff. I have no idea where it's coming from. Where the witness has read his testimony, so I object on the grounds of these very specific details as facts, not in evidence.
Ms. Lang?
I will rephrase.
Go ahead.
Earlier, sir, when you were testifying, I think it was with Mr. Freeman, when you started from the moment you started at NMGC, you started as a VP of Finance, correct?
Yes.
So in those years, you were in 2014, were you still the VP of Finance?
Yes, through the end of 2014, I was.
So you must have some familiarity with the spike in gas prices in that year.
Objection, Brian Haverly.
Mr. Haverly?
Argumentative, Madam Hearing Examiner. Must have familiarity is argumentative. It's
I
not
will
quite.
rephrase. And I wasn't
Ms.
finished.
Lang?
Yes, well, I wasn't done yet, but yes, I will rephrase. Let me think about how I'm going to rephrase this. Are you familiar, sir, with price spikes that happened in 2014? While you were the vice president of finance for NMGC?
I'm aware that prices fluctuate all the time. So I need, for me to answer that question, I have to understand what you mean by price spikes.
That there was a significant rise in gas prices following the March 2014 polar vortex storm.
Yes, I'm sure when there's weather like that, prices fluctuate and often go up. I don't recall it going up by a significant amount, and certainly nothing that couldn't have been handled through our PGAC, and I think was handled through our PGAC without any adjustments or without a request from the commission to alter how the PGAC operates. So in other words, the PGAC operated as it was intended to. If there was increases in pricing during that period of time.
As the vice president of finance and president now, do you monitor gas price fluctuations?
Not on a daily basis, but I generally know a little bit about the pricing at any given point in time. I couldn't go back in history and say, well, last year in January it was this price, but I know that right now gas is trading in the $2 to $3 range.
Let me just look at my notes here. Mr. Shell, you talk about Winter Storm Uri in your testimony, and you just mentioned it. Could you tell us what happened during Uri in terms of gas prices?
Yeah, and Winter Storm Uri was interesting compared to other storms in that prices went up significantly, actually in excess of $100 per MMBTU compared to what normal pricing would be is in the $2 to $3 range. So this wasn't just a price fluctuation. You often see during storms prices fluctuate, maybe even up to $10. But that's nothing material when you're spreading those costs over a few months in customer bills. But what happened in Uri was prices spiked to in excess of $100, is my recollection, and stayed there for several days during an extreme cold weather event. So we had to go into the market and buy gas at extremely high prices for the first time first time in a long, long time, paying prices that were really quite extraordinary. So that's what happened in Winter Storm Uri. That event took place over a weekend and over several days. And when it was all said and done, I think we had spent maybe in the neighborhood of $100 to $110 million more than we normally would. So it was significant, and so significant that we actually petitioned the commission to handle it through our PGAC. Under our PGAC, we're allowed to request from the commission extraordinary relief. It's one of the things you can do under the PGAC. So instead of collecting those costs over a few months, which would normally be the case, we requested from the commission to collect those costs over I believe it was 30 months. It may have been 36, I don't recall specifically. And the commission granted us that request, and we proceeded to collect it over a longer period to lessen the bill shock.
When you say collect over 30 months, what does that mean?
It means that we paid for the gas and we carried it as part of our PGAC balance and collected it instead of collecting it over the couple of months, which is normally how the PGAC works. That 100 million was segregated and we collected it from customers over 30 months.
Okay, so when you say collected over 30 months, the cost of the 110 million was spread through 30 months over.
Exactly. It was entirely paid for by the company. And then we charged it to customers over, and my recollection is a 30-month period. It may have been 36, but it was over at least a 30-month period.
Do you recall what the increase or was that as a surcharge? Do you recall how that happened?
You know, I don't remember specifically how it appeared on customer bills. I think we rolled it through the PGAC charge. There is a charge on customer bills for the purchase gas adjustment clause charge. And I don't recall that there was a separate charge for it. I think we just amortized that 100 million into the PGAC over a 30-month period.
Do you recall how much the increase was from what they had actually used that month plus the amortized amount?
I'm sorry. The increase.
Yes.
Well, it was. Maybe could you ask that question? I just want to make sure I'm responsive to your question.
So in the bills, I asked you if it showed up as a different, like a surcharge, but you said it got amortized. So what was the extra charge to the customers over the 30 or 36 month per month?
Yeah, I don't recall specifically what the amount was per month.
Would it surprise you if I told you it was like $11? Because I remember, because I paid it too.
Objection, Brian Haverly.
Strike that. When you say the company had to pay the 110 million, so for 3 years you didn't get that 100. How did you manage that?
Well, we went out and got a term loan and used the funding from the term loan to pay off the gas cost. So we then, as we collected that money from customers over a 30-month period, we then repaid the term loan.
I'm assuming there was an interest on it, correct?
There was interest on it, yes.
Let's see. I think I may have only 1 or 2 more questions for you. Earlier, when you read into the record that you didn't, let me, I don't want to paraphrase. On page 13, when you read into the record about the severe weather fund, on line 11, you state that you do not believe that the severe weather fund is necessary. Am I reading that correctly?
Yes, that's correct.
I'm wondering, how does the need to take out a loan to pay off the cost of swing gas align with your response on page 13, line 11?
Well, taking out a loan was just the mechanism we used to pay for that gas cost. The recovery of the gas cost from customers was through the PGAC, our normal mechanism. I guess as I think about a severe weather fund, it's not changing prices. It's prepaying for it's prepaying for the gas. or putting money in a fund to sit until an event like a Winter Storm Uri occurs. And I just think that the way we handled Winter Storm Uri, it worked in that we spread those costs out for customers, as we are allowed to do under the PJC if we make that request of the commission. So, and I'm not sure diverting the commitments we've made and some of the bill credits and things like that in this instant case into a fund that, you know, may not pay out for 10 or 20 years is the right thing for customers in trying to determine if something is in the public interest.
Do you recall what the interest rate was for the 110 million?
I don't recall specifics. I do know that at that point in time, interest rates were very, very low when we entered into the loan. I want to say 1 or 1.5%. They did increase over time over the period we were refunding that money, but I don't know specifically how high they went. As you know, interest has increased or did increase from 2021 through, I'd say, 2024. So,
am I correct in assuming that that interest cost was passed on to the ratepayers?
That was actually addressed in the filing we did with the commission. So the commission, and I'm trying to remember specifically what that order states, but the commission essentially said we could recover that interest cost, but then there was a cap on it. And I believe that cap on the interest cost was our weighted average cost of debt in our most recent rate case. So, and I don't know specifically what that is. It's probably around 4%. So customers would have paid the lower interest rate early on. And then if I believe the interest rates surpassed our weighted average long-term interest rate, so then they would have been capped at the roughly 4%.
So capped or not capped, it was passed along to the ratepayers, correct?
It was.
Would you agree with me that if you need to take out a loan, then you don't have the money available for extreme unexpected costs?
Objection, Brian Haverly.
Mr. Haverly?
It was an extremely vague question, Madam Hearing Examiner. There was extraordinary costs and nothing more than that. And you have to take out a loan. The company has many loans outstanding. So I'm going to just say that is a vague question. Ambiguous.
I will rephrase.
All right, Ms. Lay?
After Winter Storm Uri, the company had to take a term loan to pay for the unexpected gas swing prices, correct?
Yes.
So would you agree with me that since that was a necessary thing that had to happen, then the company does not have the money available for an extreme weather, if it happens again, for unexpected swings in gas prices?
Could you repeat that? I'm not sure I fully followed the question.
If it happens again, will NMGC be forced to take another term loan? When I say it, I mean swing gas prices like Winter Uri.
You know, I don't know with absolute certainty. It would depend on the facts and circumstances. At the time, we had our revolver, and our revolver is our short-term line of credit, and it was being used for purchase of other gas supplies during the winter months. So it depends on the timing. If it happened in April, then maybe our revolver would be enough to cover the gas cost, our normal short-term line of credit. In the instance you're talking about with Winter Storm Uri, we felt we should take out the term loan and leave our revolver balance for ongoing business needs. So it really depends on the facts and circumstances. It would depend on the level of the event. If it was 40 million, we might just put it on our normal short-term revolver. But in the case of Winter Storm Uri, and the fact that we were already utilizing our short-term revolver, we felt that the best thing to do was to enter into a term loan. So it depends on the facts and circumstances and the situation at hand.
Could you tell us what a short-term revolver is? Because I've never heard that term before, and I would like to understand a little bit better.
Sure, it's a revolving credit facility that many businesses enter into, and we have a syndicate of banks that provide us with a lending commitment of up to 125 million. So our revolver, we can borrow up to 125 million on our revolver, and we use that for day-to-day operating needs through the winter months because we're a seasonal business. We purchase a lot of gas in the winter months, and we use the revolver to pay for that gas because we pay for the gas prior to collecting it from customers. So we can borrow money on it, we can pay the money off. So it's different than other, like a term loan. Once you borrow that money and you pay down the principal, you can't then reborrow the principal. So a revolver is something that you can borrow on, you can pay it down, you can borrow again. It's common in the business world.
The cost of that, I'm assuming, goes into rate base or fuel.
The short-term,
The revolver, I mean.
it does not, no.
The interest you pay on the revolver doesn't go into rate base?
No, it does not. The way it wouldn't go into rate base because it's a liability, but the way rates are determined in New Mexico is you take your long-term debt and your equity. It's based, your capital structure that you use to determine rates is based on your long-term debt, not your short-term debt.
Noted. I know you said it depends, but if another storm like Uri would have happened and you had to go out and take out another term loan, the interest rates today are going to be higher than what they were in 2023. Am I right in assuming that?
Well, it was in 2021. So relative to 2021, yes, interest rates today are higher than they were in 2021.
I think I'm almost done, but let me check my notes. You know what? I think that's all I have for you. Thank you very much.
Thank you.
Thank you, Ms. Lang. Good afternoon, Mr. Shell. I've got a few questions for you. And while it's fresh on my mind, I would like to know your revolver and your other existing relationships between lending institutions or other vehicles for New Mexico Gas to obtain credit. If the commission approves this transaction, will those things change?
No, they will not. So I'll talk. There's two components or multiple components. You referred to the revolver. We actually just entered into and extended our revolver. There's a syndicate of banks that participate in that revolver, and we just extended it to 2027. So that's in place through 2027 with our current banks. Our long-term debt, those are what's referred to as private placement debt offerings, and they go mainly to insurance companies, some pension funds, things like that. Those are unaltered by this transaction as well. So they will remain in place for the remainder of their term. Some of them are 5 years, some of them are as long as 30 years. So they are in the name of New Mexico Gas Company, and nothing about this transaction is going to alter that. So our debt is the 550 million that folks have referred to multiple times throughout this hearing. So
In addition to your existing private placement and revolver that you've just testified to, will there be any potential credit availability arrangement that would occur because of approval of the transaction with BCP, any of the joint applicants or affiliates of BCP?
So for New Mexico Gas Company, the approval of the transaction will not alter our debt or cause us to enter into any new debt. Your question may relate to Mr. Baudier has talked about at Saturn Holdco. They are taking out a loan at that level. But again, with the ring fencing that Mr. Baudier has talked about, our customers will never be in a situation where they're responsible for that debt at all.
No, I just wondered if there was some type of affiliate with the BCP companies. I know that they have, I believe, affiliates that offer shared services. And I wondered if they had any investment or credit facility that if the transaction were approved down the road, that would be an opportunity for New Mexico Gas Company to have debt financed through one of those companies.
Yeah, I don't think, if I'm understanding your question, Madam Hearing Examiner, I don't know that we would do any debt financing through a related party. We would do any debt financing that we do, as we always have through banks, or when we issue long-term debt, we go into the private placement market and issue it that way.
So you, and I didn't, I don't think I don't think I limited my question to one of your upstream companies, but other BCP companies. So for example, you know, if they had some kind of credit company or bank or other infrastructure fund, you know, potentially could you get some kind of debt financing through one of those entities?
Yeah, I'm not aware that BCP owns companies that are sort of in the business of lending money. So it seems unlikely in my mind. And I know there's some in some of the ring fencing provisions in this case, I think there are actually some limitations on entering into debt with affiliates of BCP. I probably couldn't put my finger on that, but we can't, in other words, we can't enter into any debt with affiliates unless it's approved by the commission. So the commission would know if we were going to do something like that.
There's been a lot of emphasis, Mr. Shell, placed on at least during the questioning so far in this case, on what will joint applicants and specifically those in your purported structure due for New Mexico Gas, I'd like to focus more on what New Mexico Gas Company will do for the joint applicants. And I think, you know, that we've heard some testimony on the potential to get distribution if approved, and if circumstance of gas company operating would allow that. That's correct?
Yeah, if I understand your question, yes, so, and then when you say joint applicants, now that includes Emera. So I think what you're asking is
BCP.
If we're owned by BCP, what would we be thinking around dividend distributions? Is that the nature of your question?
Well, the nature of my question is that I've heard testimony that from Mr. Baudier, I guess that, and or some of the other witnesses, that potentially there could be some type of money going up from gas company up to Saturn Holdco and then up the chain. Is that correct?
That is correct.
And I'd like to know more about that. And what would the nature of New Mexico Gas Company be providing?
Yeah, so those would be dividend distributions is how I would characterize those. It wouldn't be payments for services or anything like that going up the chain like that, like you're referring to. It would be dividend distributions, and we do those today.
Right.
Today we pay dividends. We generally try to pay dividends on a quarterly basis. If there is net income on a quarterly basis. So we're doing that today. Our net income, the structure we have in place today, we dividend our net income up to our parent companies. And that is done in part to keep our capital structure in place. So when we earn our net income, it rolls into retained earnings and increases our equity. And so if we allow that to happen over time, our equity component grows and grows. So we pay the dividend with Emera, we pay them the dividend. We generally pay a dividend of our net income. And then when there is a need in the future for equity infusions into the business, they put equity into the business. You could also not pay dividends and allow your equity to grow. And then if at the time, the reason we do it the way we do it is because in a rate case, we want to maintain our capital structure roughly the same as it is in a rate case. So in order to do that, we dividend the income out. And then at a time when we issue long-term debt, the long-term debt comes onto our books and that alters our capital structure. So then we also want to get an equity infusion at the same time so that we continue to balance our capital structure in a way that it's 52% equity and 48% debt for rate making purposes. So that's the reason we have chosen to do it that way under Emera ownership.
And do you anticipate you're going to continue to do that way if the commission approves this transaction?
It is certainly a way to do it. We will probably well, we will confer with BCP and their shareholders to understand how they want to handle it as well. Because you can also, as I explained, you can get capital by just not paying the dividend. So instead of paying the dividend out over a couple of years and then getting a large equity contribution in, you can just retain those earnings in the business. So we'll work with our shareholder to kind of understand how they want to do that. My preference actually is to pay the dividends because it allows us to manage our capital structure and ensure that we stay within the range of what's approved in our rate case. In other words, what was approved in our last rate case was 52% and 48%. So from my personal view is it actually helps to pay the dividend because it helps you keep that all in balance.
And the way that you do this, is it typical for similarly situated gas companies?
I guess I can't speak for other gas companies. I know in the Emera family of companies, that's generally how it's handled. All the affiliates pay their net income up to the parent company. But I guess I can't speak with any level of authority on what other gas utilities might do.
Okay. Are there any other ways? Now, you're not, I think I heard you clarify that you're not including in my question payments for shared services. Is that correct?
Yes, I think and I apologize, Madam Hearing Examiner. I hope you can hear me. You broke up a little bit there, but
okay.
I think I understood the question to be when I'm talking about dividend distributions, I'm not talking about payments for shared services, and that would be accurate. I think you were referring to the testimony of Mr. Baudier, and he was talking about distributions. So I was talking about dividend distributions.
Right.
Yes.
Right. Okay. And I'll be more clear in my question. Again, I want to focus on what will gas company be giving to the BCP entities in your lineage chain. And I did reference the distribution testimony, but one of those other for lack of a better term, payments will be for shared services to Delta Utilities, which is, as I believe was testified, is the service company that's an affiliate of the BCP applicants or BCP companies, correct?
Yes. So in this particular in this application, we do reference entering into a shared services agreement with Delta Utility Services, and there's reference to developing a CAM in relation to that. I would anticipate that that CAM that we ultimately enter into probably looks very similar to the CAM we've entered into today with Tampa Electric and Emera. So yes, we will be making payments for services to Delta Utility Services Company.
And then what other, I'm sorry, sir, I didn't realize you were finished.
I'm sorry, I was just going to say pursuant to the CAM.
And CAM is the cost allocation manual?
Yes.
And that was another question later, but since you're referring to that, Do you expect there to be significant changes in the CAM from the existing one?
We'll sit down and work with Delta Utility Services, but my anticipation is we would continue to, make a preference for direct charges. But also we would do assessments and allocations, which are the types of allocation methodologies we use in the current CAM. So my preference would be, and I think the team here, we would try to structure it very similar to the CAM that's currently in place today with the Emera family of companies.
Do you know how long it's going to take after any commission approval to get that filed with the commission? Do you file it with the commission?
You know what? I believe, yeah, I think it's going to be filed with the commission. I apologize. It's I know there's information in our application on this. I believe it will be. I don't know if there's a timetable for it or not outlined in the application. I could flip through the application real quickly if you want, see if I could find that. But off the top of my head, I can't remember if we agreed to file it within a certain period of time. It seems to me like we would probably file it once we're about to enter into receiving those services from Delta Utilities. So it may not be within like 90 days, for example. It may be down the road. But again, I can't remember if it's specifically noted in the application or not. You guys have the application?
No, I don't see where my note was. Mr. Show. Well, you've referenced the CAM on page 8 of your line 18. You say see joint applicant exhibit RAS-2 revised application. So it was attached. The current one was attached to your direct testimony.
Yes, you're right.
And I just wonder, like I say, if you know, like how long it took you and New Mexico Gas Company to create this after TECO was acquired by Emera.
I do not recall how long it took to put it together and file it with the commission.
Do you recall whether or not your attachment RAS-7-2 what you would consider substantially different than the CAM that you modified?
My attachment, my JA exhibit RAS2,
Uh-huh.
is it substantially different than the one that we would have entered into in 2014?
Yes.
Yes, because this one is dated January 1st, 2020. I don't know that I don't think it was substantially different. No, we've been doing allocations roughly the same way since being acquired by Tico Energy. So I suspect it was they're very similar allocation methodologies have been applied really since 2014, and I would expect that to continue going forward under new ownership if this acquisition is approved.
So back to my question on what is gas company providing to the BCP companies involved in this transaction or other BCP companies? So far we have dividend distributions, we have shared services agreements with Delta Utilities. Any other shared services agreements with any other BCP companies?
I'm not aware that at this point in the process, I'm not aware of any other BCP companies that we would have a shared service agreement with.
Is New Mexico Gas going to be responsible for any of the BCP partner management expenses that I believe according to Mr. Baudier's testimony, will be incurred by some of the other participants, whether it be Saturn Holdco, or any of the intermediate companies, or any of the infrastructure funds. Is my question clear?
If I understand it right, you're wondering if we're going to be paying for any fees, Bernhard Capital Partner management expenses. And
Yes.
my understanding is New Mexico Gas will not be paying for any costs associated with Bernhard Capital Partners management. My understanding in listening to Mr. Baudier's testimony was that the investors pay Bernhard Capital Partners management fee for operating in their capacity. But it's not my understanding, at least, that New Mexico Gas Company will be paying Bernhard Capital Partners management any fees.
Any other type of payment that I haven't categorized that you know of, gas company will be responsible for paying.
Yeah, the only other thing, and this really just relates to New Mexico Gas Company and New Mexico Gas Intermediate, the immediate parent company of New Mexico Gas Company. We would likely, those two entities would be filing a consolidated return in all likelihood. So there may be tax payments back and forth between, and these are income tax payments back and forth between New Mexico Gas Company, Inc. and New Mexico Gas Intermediate, Inc. And those types of payments take place even today under our current structure.
So no other payments upstream to any of the joint applicants, not referring to Emera and that part of the joint applicants, but the BCP companies that are joint applicants.
No, I think that's at least the facts as I know them today would simply be the dividend distributions, the payment for shared services, and potentially any income taxes that need to get paid to the immediate parent company of New Mexico Gas. That's all I'm aware of at this point.
All right, sir, thank you. Are there any payments that New Mexico Gas Company currently makes to Emera and or Tico up the line that you would not have to pay under this kind of structure with the BCP applicants upstream of gas company? In other words, are you getting rid of any payment if the commission were to approve the transaction?
I think the one thing that you might be able to characterize is getting rid of is some of the public company costs that currently get allocated down from Emera to us. So that will go away in the process. And under BCP ownership, as I believe Mr. Bodier has testified to, there's no intention of charging any cost from BCP management to New Mexico Gas Company. So that would be a difference, I guess, is we wouldn't be paying what I call our cost for access to capital, I guess. Emera is a publicly traded company, so they have costs of being publicly traded, which get allocated to their subsidiaries. And so under Bernhard Capital Partners Management, my understanding is they do not charge for those types of services for the fact that they help us gain access to capital.
So there's not a corresponding private equity cost.
Yes, you said it better than I did, but yes, that's that's exactly what I'm trying to say.
Being similar to your public company costs, you don't see that that New Mexico Gas Company is having to pay any specific type of cost because of the ownership type of BCP.
Yes, that would be how I characterize it. That's exactly right.
wanted to ask you, having been more intimately aware of the last gas company rate cases, I think as it might be phrased, and having heard that testimony, I wanted to ask you about your testimony on page 11. The question posed at line 10, will New Mexico Gas Company's gas operation be negatively affected by the transaction? And then you begin your answer at line 12 with no. And one of the protections, as you characterize it, begins at line 14. And I want to focus on what at the end of line 16, agreeing to invest a minimum of the rolling 3-year average for depreciation and amortization expense on an average annual basis in the New Mexico Gas Company system as needed to ensure reliability and safety until the issuance of the final order in New Mexico Gas Company's next general rate case. That's your testimony, sir?
Yes, that's the testimony in my revised application, direct testimony.
So, why is that? Why did you choose to use that benchmark?
Yes, I don't know if this is a great answer, but the answer is because it has been used in prior cases. So that provision was in the 2009 acquisition of the gas company by the Lindsay Goldberg private equity firm. And that same language then just rolled to the TICO acquisition case, and then it rolled to the Emera acquisition case. And so we rolled it to this one as a commitment in the case.
I'm sorry, go ahead.
That has since changed. I believe we've committed to, in response to intervener testimony, we committed to the providing capital for the 5-year capital plan, essentially. So I think VCP has agreed to commit to capital spending at the level of our 5-year capital plan.
When was and what the 5-year capital plan? Which one are they committing to, and when was it authored?
My read of that would be we have a rolling 5-year capital plan for the business that management here determines and we get board approval for. So my understanding of this provision is that BCP and the funds that will own us are agreeing to allow us to execute on that 5-year capital plan.
So that 5-year capital plan is voted on a yearly basis when?
Yeah, so our 5-year planning cycle, every year we do a 5-year plan. So 1 year rolls off and another year rolls on, obviously, when you're doing that. And then the years in the middle, you continue to refine those years. So our 5-year capital plan that we do for 2025, when we go into 2026 and do another 5-year capital plan, the capital may change amongst those years. So I guess the way I view it is they're agreeing to our ongoing capital plan as put forth by management and agreed to by the board.
And you believe that, well, let me ask you this. That may be New Mexico Gas Company's rolling 5-year plan for capital, investment. But that amount of the 5-year plan, does it actually get funded?
Yes. It would get funded through our normal process for funding our capital, which would include debt funding and equity contributions from our ultimate owner. So that's how that gets funded.
Well, I'm mainly wondering, if you have, a replacement plan, that, you want to do this and that, and you want to build new, offices and things like that. Then you come in a rate case and you don't always get allocated, you don't always get approved, right?
That's correct. Through the course of a rate case, perhaps some of our capital does not get into the final order in the case, or there's a whole wide variety of things that can happen in a rate case, of course. So yes, and I guess this commitment is until the next general rate case. So they're essentially agreeing to continue our 5-year forecast until that next rate case. So if in that next rate case, the commission wishes to alter our capital spending or O&M spending, then we would change course and follow whatever the commission is authorizing us to do.
So you don't see any, you don't see any negative effect to that part of the gas operation if the transaction were approved. Do you see any potential benefit to, being able to do more of your replacement projects or upgrade more of your systems with this type of ownership, potential or not?
Are you speaking specifically to this commitment?
Yes. Or the new commitment to fund the
Yes, I
5-year
suppose
plan.
I suppose with that commitment, it is a commitment, and we don't currently have that commitment under the status quo. So you could argue that this commitment provides a benefit to the transaction. In reality, though, under, at least so far, under current ownership, the capital plans that get put forth and approved by our board, that has been honored by our current shareholder, and I would anticipate it being honored with the new shareholder as well. So, but I guess the only thing I could see there, Madam Hearing Examiner, is there is a commitment here, whereas under the status quo, there is no commitment.
Okay. On page 14 of your testimony, the question posed at line 4 and 5, are you concerned that Emera/TECO will no longer own gas company if the transaction is approved? Your answer begins on line 6, and you answer no, and then you go on to answer. And I just would like a little clarification as your answer continues on at the end of line 10. On page 14, you say, in addition, the support that we will receive under new ownership appears to be readily comparable to the structure under which we have been successfully serving customers and operating the business over the last decade. That's your testimony, sir?
Yes, it is.
How do you define readily comparable?
Well, under current ownership, local management really operates the business. And so that will remain true under new ownership. And under current ownership, we have a shared service environment, or we have a shared services company providing shared services to our business. That will be the same under BCP fund ownership. It's gonna be altered a bit with some of those functions actually returning to New Mexico, and we'll be hiring around 20 folks to do some of that work that is currently done through shared services. But the overall model is still in place where we're using a shared service structure to handle our IT and cybersecurity. So that's what I mean by readily comparable. The other thing I would mention too is, we do have access to Emera executives and to other affiliates in the Emera family of companies. And I expect that to continue under new ownership. We'll have access to several different gas utilities in Mississippi and Louisiana. And we'll also have access to folks or personnel at BCP management. And I know that a lot of interveners have indicated that BCP does not have the experience, but I think they're referring to BCP as the legal entity. If you look to BCP, the people who work at BCP, I think they have a great deal of experience, and two of those individuals actually have testified in this case. And I think hopefully the commissioners and you as hearing examiner and hearing examiner Schaefer view these people positively as well and see that they have very extensive utility experience.
Thank you, sir. Is there any part of New Mexico's gas system as it exists today that could be segregated off for potentially a separate company or potentially to be sold?
I suppose you could do something like that. I don't think that that's anticipated. It's certainly not anticipated by me, but for example, we have different regional operations. I suppose they could be separated off and sold. Theoretically, yes, that could happen.
No, I'm sort of thinking about Public Service Company of New Mexico, and don't they have two distinct sort of systems with the Northern and then the Tex New Mexico?
Yeah, I see what you're asking. And so, yes, we would have, our system is set up in pieces as well. We have what we refer to as our Northwest system. It's all interconnected from Farmington to Gallup to Grants over to Albuquerque and up to Santa Fe and then on up to Taos. That's all interconnected. Then we have our Southeast region, Carlsbad, and the communities in the southeast part of the state, primarily in the Permian Basin. They're all connected. And then we have a couple, we call them remotes. So like the Clovis area of New Mexico is really not connected to our system. We actually connect to interstate pipelines to feed into the Clovis area, and Alamogordo and Silver City are the same way. We call them our remote operations.
Does New Mexico Gas Company and or New Mexico Gas Intermediate and or the part of TICO that's being considered to in this application? Do they have any separate assets other than the assets that are currently being utilized to provide gas service in New Mexico? For example, real estate?
Are you referring to the two immediate parent companies of New Mexico Gas Company, New Mexico Intermediate, and Tico Energy LLC?
Yes.
They have no assets other than their investment in the underlying subsidiary that they own.
Does gas company have any other assets that aren't being utilized to provide gas services like real estate?
We have buildings. For example, I'm sitting in our headquarters here in Albuquerque, so we do have, you mentioned real estate, so I mentioned this building, and we have buildings around the state, but they're all used in the provision of providing service to customers. So we
But you
have,
actually,
I was
go
gonna
ahead,
say-
sir.
Yeah, sir. As far as I know, we don't have any assets that aren't currently being utilized to serve customers.
Does gas company actually own the buildings?
The building I'm sitting in, we do own, and we own several buildings around the state. We also rent certain facilities as well.
Is there any plan to sell the buildings and then rent them back to you?
There's no plans for that.
I believe Mr. Show. I believe that's all the questions I had for you, sir. Appreciate your time. I believe at this point it's 3:20. Let's take a 10-minute recess. We'll come back for any redirect. Well, I
Hearing
forgot
examiner.
I'm sorry, hearing examiner Schaefer. I forgot to ask you if you had questions. We'll come
It's
back
okay.
if
It's Friday at
hearing
30.
examiner Schaefer, can we take our recess before you ask any questions?
Absolutely. I was going to suggest that.
Awesome. Very well. Let's take a
Okay.
10-minute recess. Please remember we are on the YouTube, and you might want to mute your Mr. Lee, how are we doing?
Judge, I can't get my system back on. Hold it. And if I can be off the screen, I'll stay off the screen.
Okay. Whatever you need, sir.
Go ahead, Judge.
Very well. We are back from our afternoon recess, and I believe that hearing examiner Schaefer has some questions for you, Mr. Show.
That's correct. Thank you, Madam Hearing Examiner. Mr. Shell, thank you again for being here with us and for all your perseverance during the questionings yesterday and today. I wanted to ask a question just immediately to follow on something that Hearing Examiner Hurst asked you a few moments ago. And you said that there's tax payments that go back and forth between New Mexico Gas Company and New Mexico Gas Intermediate. Am I correct?
Yes. So we file a consolidated tax return with New Mexico Gas Intermediate. We have since 2009 when both entities were created. And New Mexico Gas Intermediate is the parent company of New Mexico Gas Company, Inc. So, and they have no activities. So really the entirety of the taxes owed or refunded are attributable to New Mexico Gas Company. But because they are the parent company listed on the tax return, I believe the tax payments need to go through New Mexico Gas Intermediate. So there are payments back and forth for that.
You have also referred to New Mexico Gas Intermediate as the shareholder of New Mexico Gas Company. Is that correct?
Yes, they are.
And
they're our immediate parent company.
And how many shares of New Mexico Gas Company does New Mexico Gas Intermediate own?
I don't know with certainty. It's a very minor number because they own 100%. So it may be 5, it may be 100. I'm not sure. It's a very minor number.
Is there any distinction in those shares between distribution rights?
No, not that I'm aware of.
Are you aware of the dividend structure or distribution structure between New Mexico Gas Intermediate and TECO?
So TECO Energy LLC, it's an LLC. So dividends going up to the LLC would, well, let me back up. Mr. Baudier testified to the fact that once they acquire once they acquire TECO Energy LLC, they're going to change the structure of that organization. So it is I don't remember the exact term he used, but it will not have 2 different membership interests as it currently does today. So essentially, I believe the LLC membership interest at the TECO Energy level will also be consistent. There will be no 2 different types of LLC membership interest.
Does TICO own shares of New Mexico Gas Intermediate?
Yes, New Mexico Gas Intermediate is a corporation, so it has shares.
And how many shares are there of New Mexico Gas Intermediate?
Yeah, again, it's a very minor number. I don't know what it is, but I would say it's anywhere. It would be maybe 5 shares. It may be all it is, or it could be 100. It's a very minor number because they own 100% of the shares. There was no reason to have a million shares.
And is it correct that those shares also have no distinction in terms of distribution rights?
That is correct as far as I know.
And by any, I mean, will any of the distribution rights between of the shares of New Mexico Gas Intermediate or the shares of TICO change? That is to say, insofar as you're aware, post-transaction, if approved, would the shares that Gas Intermediate holds in Gas Company change, and likewise with TICO vis-a-vis New Mexico Gas Intermediate?
No, they would not.
Are you aware of any plans to reorganize the share structure of TICO? That is to say, are you aware of any post-transaction plans by joint applicants to change the way that Saturn Utilities Holdco owns TICO versus how Emera currently owns TICO?
I'm not aware of anything. I do recall, as I mentioned earlier, Mr. Baudier testifying to the fact that there are membership interests at the TICO Energy LLC level that will be modified post acquisition, I believe, into a single class of membership. So that's the only thing I'm aware of.
Okay, and in your experience, would that kind of change result in any expense to the gas company, any upstream expense?
I think that's well, I don't want to say it's relatively minor, but I would think that that's just a legal cost that I would not anticipate would come to New Mexico Gas Company. But in any event, I think it would be relatively minor.
The intended transaction, the proposed transaction, also calls for, well, the purchase price includes this question of $550 million of debt. Is that correct?
Yes, as part of the purchase price calculation, you take into account the debt of the business in determining the amount of cash that gets transferred from the BCP funds to Emera.
And that 550 million in debt, that currently is owed by New Mexico Gas Company. Is that correct?
Yes, it's a forecast of what our debt will be at the closing. And I might just correct something I just said, hearing examiner Schaefer. I said that the funds would flow from the BCP funds. The funds will actually flow from Saturn Utility Holdco. So I just wanted to make that clear.
Thank you. Now, the 550 million, the projected $550 million debt that you just referenced, post-transaction, is that going to be assumed by Saturn Utilities Holdco? Is to say, is Saturn Utilities Holdco going to pay that off on behalf of the gas company?
No, that debt will remain on New Mexico Gas Company's books. Sometimes it gets a little confusing in acquisitions when they refer to assuming debt. That's not really what's going to occur. It's a way they refer to purchase prices in M&A transactions. So they oftentimes will refer to the entire enterprise value of the business, and then we'll say, well, there's already 550 million of debt on the business, so the equity that will be paid is essentially the purchase price less the debt. So that's why they often refer to that as assuming the debt, but technically it's New Mexico Gas Company's debt, and Saturn Holdco won't be assuming it in the legal sense.
Okay, so there'll be no assignment or transition of liability or anything like that?
No, there will not.
Okay. So the purchase price then really constitutes the $250 million loan that Saturn Utilities will assume and the 448.9 million in equity. Is that correct? In order to purchase TECO and the downstream companies that it owns. Is that correct?
Yes, that's how they are funding the actual cash payment at closing is through a $250 million loan at Saturn Holdco, along with the equity infusions that come from the ultimately the BCP funds.
Now, do you see any risk to New Mexico Gas Company if that loan, if Saturn Utilities Holdco defaults on that $250 million loan?
No, I do not. With the ring fencing that's in place, I think New Mexico Gas Company is protected from any default on the Saturn Utility Holdco loan.
Can you explain that ring fencing?
Yeah, it's not legal ring fencing. I would describe it more as regulatory ring fencing as outlined in this case. So there's a whole bunch of provisions in the and I don't have it in front of me here, but attached to the application and attached to Mr. Baudier's testimony that goes through nearly 100 commitments, and part of those commitments are the ring fencing commitments. So they're all outlined under the section titled ring fencing.
Okay, so how does that translate legally? How does that translate? I won't ask two questions. I'll ask one question at a time. But how do those commitments translate legally? What's the legal basis for that inability to go after TECO, Gas Intermediate, or gas company for any default on that loan?
Yeah, I think I'm not answering as a lawyer here. It's a bit of a legal question, but just as a layperson and understanding how corporate structures work, with a corporate structure in place, in multiple layers of corporate structures, I believe that that provides a great deal of protection. And then there's also the regulatory protections contained in this application, things like commitments not to pay dividends when our credit metrics are below investment grade. So there's a number of limitations around dividends that have been in place in prior acquisitions, and we're putting that in this application as well. So I guess as a layperson, I would just point to the structure and the multiple layers of entities between us and that debt, and then also just the dividend limitations that are outlined in our commitments.
Okay. But you're not aware of any legal provision that would prevent a creditor from pursuing a default at the utilities holdco level downstream?
Yeah, I'm not. I believe that would be a difficult thing for a creditor to do, given the corporate structure and that's in place and the multiple levels of corporate ownership. I don't see that. There's a concept, and I don't want to be an attorney here, but there's a concept called piercing the corporate veil. I don't see that happening here, where this is a well-managed organization and we have the governance in place to prevent that sort of thing from happening.
Ms. Hutt yesterday stated that Emera was selling the gas company at a loss. Is that also your understanding?
Yes, it absolutely is.
And has New Mexico Gas Company been profitable in recent years?
Yes, we have filed regularly for rate increases, and we have shown a profit every year for as many years as I can remember.
I'd like to take a second and refer to a portion of your revised direct testimony. So we can take a second to get there. This is on page 17. And the question is, well, I don't need to read the question back into, well, maybe I will, just for formality purposes. Do you believe it is necessary for New Mexico Gas Company to be required to provide financial disclosures to the regulator and to the public equivalent to those required of publicly held companies, including 10KS, 10QS, and that New Mexico Gas Company otherwise be held to the rules applicable to companies on the New York Stock Exchange, including the Sarbanes-Oxley Act, and on the same cadence as publicly held companies? Is that the question?
Yes, it is.
And you posed this question to yourself, is that correct?
Yes, I did.
And why did you pose this question to yourself?
There was a lot of discovery that essentially alluded to filing these sorts of reports. So we were aware through the discovery process with interveners that they were suggesting essentially that we do this. So I wanted to address it in my direct testimony.
Post-close, if the proposed transaction closes and is approved and then closes, will New Mexico Gas Company not file certain disclosures that it is currently filing with the federal government or other institutions, governmental institutions?
Well, New Mexico Gas Company will continue to file what we've always filed with the commission. Because we're owned by a publicly traded company, in both TECO Energy acquisition case and the Emera acquisition case, they were both publicly traded companies. So in those cases, we agreed to provide the reports that TECO in the first instance and Emera in the second instance, that they file with their government regulators due to their status as a publicly traded company. I'm sorry, I kind of stumbled through that. For TECO Energy, it was the SEC, and for Emera, their stock is traded in Canada, so it would be the equivalent in Canada. Now, Emera has just recently listed on the New York Stock Exchange, so they are, over the next 2 years, will be becoming compliant with New York Stock Exchange rules and Sarbanes-Oxley. But up until their recent listing on the New York Stock Exchange, they were not required to comply with New York Stock Exchange rules or Sarbanes-Oxley regulations.
If approved and if the transaction closes, will New Mexico Gas Company be reporting less than it is currently now?
Only to the extent that we will no longer have a public utility or a public holding company, so we won't be filing those reports that our ultimate parent company has filed. But New Mexico Gas Company, as I've outlined in the answer here, and I won't go through all of that in detail, New Mexico Gas Company will continue to file the pretty extensive reports that it has always filed with the commission and is required by the commission to file.
Is New Mexico Gas currently filing a 10K with the SEC on an annual basis?
No.
Is it sending and reporting information to Emera for its 10K?
Yes, New Mexico Gas Company financial information does roll up into Emera's consolidated financial results, and and throughout their report, there is reference to New Mexico Gas Company. It's relatively minor because we're only about 5% of Emera. So the references to New Mexico Gas Company are in there, but it's not as prevalent as Tampa Electric or Nova Scotia Power.
So New Mexico Gas Company then will have less reporting if the transaction is approved and closes than it does now. Is that correct?
Yes, yes. Those publicly traded reports from our parent companies, we will no longer be filing.
Turning again to this question on page 17, the answer on line 14 and 15, the first line of the answer says, requiring this level of disclosure is unnecessary and would be costly to the customers of New Mexico Gas Company. Is that correct?
Yes.
And is there any detailed cost analysis that New Mexico Gas or joint applicants conducted to determine what that cost would be of reporting similar reports to the 10KS and 10QS?
Yeah, there isn't a formal report, but this is something I look at periodically, just in our annual review of the costs that get charged from Emera. So just to, we're required to evaluate our shared service costs that come through on an annual basis. So we get charged about $2 million from Emera for their strategic oversight of the business, governance, and access to capital, essentially. And so I have to determine, is $2 million a reasonable price? And when I look, and this is just simply internet, I go out on the internet and search and look for things. I find studies. Recently in 2023, there was a study done by some graduate students from Columbia University, and they had a variety of different things that they indicated in there. But the lowest that I could find, I was seeking the lowest possible cost to be a publicly traded company, and it was when I equated it to our capital structure, because it's based on the amount of their study was based on the amount of capital stock you have in the market. So for us, that would be about 600 million. I came up with a number of about $8 million would be almost a minimum for New Mexico Gas Company to try to operate as a publicly traded company and abide by all the rules of the New York Stock Exchange and Sarbanes-Oxley.
Let me see if I understand. You are saying that the cost to New Mexico Gas Company would approximately be $8 million to provide similar reporting that publicly traded companies do.
Yes, this is a estimate on my part based on reading some studies. That it was a simple Google search to just satisfy my own understanding of what it might cost. It can range. I picked actually the lowest number that was in that report. If I use the higher number, it could cost as much as 30 million. So it was a very comprehensive study of what it costs to be a publicly traded company, and they gave a range of potential costs. And the purpose of the study was to determine, actually, if you're interested, when people are close to thresholds. So in other words, there's different thresholds when you're regulated under in New York Stock Exchange. If you're 25 million or less of capital stock, you're treated as a small issuer. If you're 75 million or less, you're treated one way. And then if you're over 600 million, then you're treated a different way. So anyway, it was evaluating and studying if people are close to those thresholds, do they take steps to be under the threshold so they don't have to incur further regulations. So anyway, that was the purpose of the study, but that probably doesn't matter for purposes of this case. I was using the study to gain an understanding of what it would cost to be a public company, given our size and everything. And I just tried to be as conservative as possible. And one of the more conservative numbers in that study would have indicated that it would cost us about $8 million to be considered a publicly regulated company and and operate under all those rules and filing requirements.
What is how does New Mexico Gas Company view the value of that kind of transparency for the customer?
Well, I actually view transparency as being very positive, and we try to be very transparent. And what I tried to answer in the question that was posed here on page 17 was that we do currently file very extensive information with the commission. The FERC Form 2 alone, I think, is I'm guessing it's around 150 pages long, and it's only New Mexico Gas Company with very detailed information regarding our financial results and activities during the year. And then we have other information that we file with the commission regarding anticipated financings and intercompany charges, affiliate charges. We provide a lot of detail on that as well. So for me personally, it feels like we are filing an immense amount of information that the commission and interveners can use that actually is probably way more meaningful than Emera's public filings, to be frank, because we're 5% of those filings, and you really can't look at those filings and determine much out about New Mexico Gas Company on a standalone basis. So I just, I believe in transparency, and I want to be transparent as an organization, but I believe what's currently required of New Mexico Gas Company by this commission provides extensive transparency on our business. So we have all those filings, and then we also file rate cases that have an immense amount of information in them too about our business. So I do believe in transparency, and I think the filings that we currently file with the commission provide adequate transparency for the business.
In your answer to which you just referred, you state by way of preface that New Mexico files, and then you listed those the GAAP financial reports in accordance with GAAP, an external independent accounting firm, and then two, also the FERC reports that you just mentioned, and then three other financial information. Is that correct?
Yes.
Now, you wrote files. Does that mean that post approval and post close that New Mexico Gas will continue to file all these reports?
Yes, we will.
And specifically with respect to the third item there that we've just been looking at, other financial information related to existing and forecasted capital structure, future debt and equity financing, affiliate transactions, and capital investing activities. Does New Mexico Gas foresee any change in the publicly accessible nature of those reports?
No, they'll be filed in exactly the same way they're filed today and available to the public through the commission's website.
So New Mexico Gas doesn't see any significant impact on the transparency of its reports and disclosure post-close. Is that correct?
That's correct.
Mr. Shaw, I just want to ask maybe a final question here. What risks does New Mexico Gas see in the proposed transaction?
Yeah, that's a great question. When I look at the transaction, I don't actually see a lot of risk that's different than the risk we have today. We're still operating a gas business, and that comes with a number of risks. So I think we're just focused on the risk associated with a change in ownership. And I don't see a lot because I primarily realize there's a test that the commission has to go through to approve the transaction. But in my seat at New Mexico Gas Company, I really look to a parent company to be able to provide capital. That's ultimately, at the end of the day, what I need out of a shareholder. And under both scenarios, I think I don't see really any different risk under BCP versus under Emera ownership as far as getting capital. The other thing that's always just a nice thing to have for me is that I have access to people that are smart people and very astute business people. And I think I have that currently with Emera, and I think I will have that under the BCP ownership as well. So that's just that's just icing on top of the cake. But from my perspective, I need access to equity capital, and it's provided under both scenarios. And I don't see that one is riskier necessarily than the other.
Thank you, Mr. Shell. On behalf of Hearing Examiner Hurst and myself, we wish to express our gratitude. Don't let the seriousness of my aspect confuse you. It is much appreciated, the time that you have spent with us, and that all witnesses have spent, and that all witnesses will spend with us. So I have no further questions, Hearing Examiner Hurst. And once again, thank you very much for your time, Mr. Shell. Very much appreciated.
And thank you, Mr. Hearing Examiner.
Thank you, Hearing Examiner Schiffer. Mr. Haverly, are you going to have any redirect for Mr. Shell?
Madam Hearing Examiner, I do have a question, but I think it may be more up to you. I did locate the information about the CAM from 13-231 under the TICO acquisition that you were asking about in terms of when it would be filed, when it was filed, and what the provisions were. I can walk the witness through that, or I can give you the citation to the exhibit to the certification stipulation for that. It's your pleasure. I'm good either way, but whatever you would like for your record, I would be happy to do.
Okay, hold on just 1 second. Unlike you, Mr. Shell, I do not have I don't have the dedicated or any persons helping me out in a
I'm very fortunate.
well, what ended up happening is I get things set up, and then I was looking for something in InfoShare, and then when I came back, I had exited out of my Dropbox, which is not a good thing. Mr. Haverly, where did you locate said document?
So, Madam Hearing Examiner, if you're looking at the certification stipulation, and I'm looking at the NM area exhibit number 43 that I believe you took administrative notice of, the stipulation is attached, and it's paragraph 28 of the stipulation that talks about creating a CAM, and that the CAM would be filed with the NMPRC, and paragraph 28. And I have that as PDF page 104 of that exhibit, if that's helpful.
Okay. So I'm assuming, well, I won't assume anything. Mr. Shell, do you have the copy of the stipulation that your attorney, Mr. Haverly, has just referred to as being the stipulation attached to the certification of stipulation back when we used to do those things? 13-00231. That's part of the new efficiency. You don't need to attach these things. They're in the record. So,
And
Mr. Haverly,
I'm working on getting a copy of that, ma'am.
okay. Mr. Haverly indicated that you'll want to look at the stipulation itself, paragraph 28. And you all keep referring to the PDF page. I don't even see where that's located, but it is page 9 of the stipulation.
Is the stipulation an attachment to this order?
It's it's an attachment to the certification of stipulation. So go all the way to the back.
And you said paragraph 28?
Well, that's the paragraph.
Yes. You want me to read what's in
I
that
want you to
paragraph?
look, yeah, I want you to look at that.
Yes.
Okay, does that refresh your recollection of the CAM that Tico and Gas Company entered into in case number 13-00231?
Yes.
And is that well, basically, I think your memory was correct, wasn't it? That the draft CAM was going to be provided to the commission within 90 days of closing?
Yeah, I believe this is actually, it would be, a draft would be provided to staff within 90 days of closing. And
Okay.
it will be filed with the commission within 6 months after closing.
Okay, yes. And is that the parameter that you're thinking about for this case, or?
Well, this case is interesting because we won't be immediately receiving services from Delta Utility Services. So I don't know that we would have something within 90 days, but if the commission desires to have, or if staff wants something, I think we can get it to staff within 90 days. I think we could probably commit to this if that's what the commission would like. I'm just pointing out that we may not actually be taking services from Delta Utilities until perhaps many months after the closing. So, but I think I can commit to working with Delta Utility Services and trying to develop a CAM and get a draft to staff for review and hopefully get that filed within 6 months. So we can agree to that.
Okay. Very well. Mr. Haverly, will you make sure that that gets added to the list of commitments?
Yes, Madam Hearing Examiner, I will do so.
Okay. Thanks for finding that, Mr. Haverly.
You're welcome, ma'am.
Do you have any I don't really consider that redirect, but
No.
That was more helping with the examination. Do you have any redirect?
One question for the sake of the record, Madam Hearing Examiner.
Very well. Go ahead.
Or I should say one subject matter. Mr. Shell, when you had a discussion a few moments ago with Hearing Examiner Schaefer about information that is filed. Do you recall that?
Yes, I do.
Does New Mexico Gas Company make any filings with the PRC in regard to public filings that are done by Emera?
Yes.
Would you please describe those?
Yes, those are because Emera is a publicly traded company, they have certain filings they do to the Canadian equivalent of the New York Stock Exchange and the SEC. And so we provide those filings with the commission. And they also file 8Ks occasionally, I think, and then we file those as well. So any filings they're doing with their regulator, and that is the equivalent of the SEC or New York Stock Exchange.
But those are taking the filings that are already made with the regulators and then filing them with the PRC. Is that what you're saying?
Yes.
Okay. Madam Hearing Examiner, I just wanted to clarify that for the record. I have no additional questions for the witness on redirect.
Thank you. Are there any questions for recross based upon my questions or Hearing Examiner Schaefer's questions, the redirect? No, everyone is tired.
Yes, ma'am.
We have, oh, you do,
I do
Ms.
have
Lynch.
some questions. Yes.
Okay, go ahead.
Apologies.
If we're going in order, I have a question as well.
Okay, anybody else have question? Nope, just the two. Yeah, let's go in order. Go ahead, Ms. Nanasi.
Thank you. So, Mr. Shell, Madam Hearing Examiner Hurst asked you about, do you have any plans to sell the buildings to the gas company? And so I want to follow up on that. If BCP or anybody at BCP asked you to sell the gas company real estate that you own, could you prevent that from happening?
Well, they could certainly ask me to look at that. My team would do an evaluation, but ultimately we would want to make sure it's in the interest of customers if we were to do anything like that. So, if we decided to evaluate that, we just look at it from a customer point of view and we wouldn't do anything unless it made sense from a customer perspective.
Would you have to get commission approval to do that?
I'm not aware of a requirement to get commission approval to sell our real estate.
Have you heard about the whole Toys R Us having to sell their, that the private equity owner of Toys R Us made Toys R Us sell their real estate and then lease back the buildings from the private equity owner? Did you know about that?
I'm not aware of that.
Okay, no further questions.
Thank you, Ms. Nanasi. Would the local board have to approve that kind of transaction, or would that just be considered in the normal course of business?
That would certainly be something this is a bit of a hypothetical, but if we wanted to sell our headquarters here, that would certainly be something that our board would be apprised of. I'm not sure. I'd have to talk to my general counsel on whether or not that would rise to the level of something that our board would need to approve. But we would certainly not do something like that without making sure our board was well aware and understood that there was some level of benefit for the company and its customers.
Okay, thank you. Ms. Lynch, you had some questions?
Yes, thank you. Hello again, Mr. Shell. I have, I don't know, 6 or so questions that I'd like to refer you to. The first one goes back to the issuing of debt when New Mexico Gas Company issues debt, BCP will provide a cash infusion. Do I have that correct?
Yeah, well, that can happen in a couple of ways. In the situation where our owner is taking dividends of our net income on a periodic basis, in that instance, yes, if we issue long-term debt and we would request, because we want to keep our capital structure in sync with what we've agreed to with our regulator. So for example, we've agreed to a 52% equity, 48% long-term debt capital structure. So anytime we get to a point where we need to issue long-term debt, we would be requesting also an equity infusion, such that we maintain that 52% equity, 48% long-term debt. Now, I did describe something earlier in my testimony where if our shareholder indicates that they prefer not to take the dividends and reinvest that in the business, then there may not be a need for that. So it'd depend on the facts and circumstances as we move forward. But under the status quo, that is how it operates. And ultimately, what we want to make sure happens is that we keep our capital structure in line with what we've agreed to in the regulatory process. So that would be what we aim to do as a business.
Okay. And if you're able to, what was the average infusion that Emera provided to New Mexico Gas Company over the course of Emera's ownership of New Mexico Gas?
I don't know over the entire course of their ownership. I think I made a note here somewhere. I know they've infused about 200 million into the business over the last several years. That's not going all the way back to their initial ownership of the business, but I do know in recent years it's about 200 million that they infused into the business.
Over 3 years? That's 200 million total over 3 years?
I've got lots of notes in front of me. Let me see if I can find that. I'm sorry, Miss Lynch. I can't seem to put my finger on that. Yeah, I apologize. I got a big binder full of stuff here, and I know I wrote it down somewhere, but I can't find it now. So I apologize. I do know it was 201 million, but I don't remember if that goes back 3 years or 4 years or 5 years. But it was not the entire ownership period. But it has been. I believe it's probably falls in the window of the last 5 years.
Okay, and that would be the total infusion over the 5 years.
Again, I don't know exactly the period.
But I mean, that's okay. I guess I'm trying to figure out, is that over 5 years total, or would that be, 200 million in year 1, 200 million in year 2?
I recall that over the period I was looking at, and I believe it was 5 years, there was 3 years in which equity infusions came into the business in differing amounts, but the amounts added up to roughly 200 million.
Okay. Do you know, will New Mexico Gas Company receive invoices from BCP for any public filings that BCP makes?
It's my understanding that there won't be charges between BCP management and New Mexico Gas Company.
Okay. And then I just would like to ask a few
Wait
questions.
1 second. Hang on.
Okay.
I just wanted to understand that last question and answer. Go ahead.
Last questions refer back to the topic that was explored regarding retirement. Who currently, meaning which vendor, manages New Mexico Gas Company's retirement plan?
Are you referring to like our 401k?
Yeah.
Okay. The vendor for that is a company called Empower,
Okay.
and our 401k is with Tampa Electric, Peoples Gas, and New Mexico Gas.
Okay. So would the management of the retirement funds change at all under BCP's ownership?
Madam Hearing Examiner, this is Brian Haverly. I object.
On what basis?
To me, I think this is beyond the scope of the questions that were asked by the hearing examiners.
Hearing examiner Hurst, you specifically
Lynch?
asked about retirement. And so I was following up on relevant questions regarding whether those funds would be used or changed at all under BCP ownership.
I don't think I asked about retirement, Ms. Lynch. But I did ask about changes. So I'm going to overrule the objection and answer if you know, Mr. Shell.
I don't even recall the question, Madam Hearing Examiner. I apologize.
Okay, the question was.
I have it right here.
Okay. Would the management of the retirement funds change at all under BCP's ownership?
No, we're actually in the process of evaluating all that now because we have to be prepared for a potential close and transferring all our benefit plans. So the intention right now is that all our current vendors, we would continue from a materiality standpoint, at least, we're going to continue with all the current vendors that are currently being used for all of our benefit plans. There may be a couple of minor ones that change, but the vast majority are going to be the same vendors administering our plans.
Ms. Lynch?
Okay, my last question is, does BCP know whether any New Mexico Gas Company retirement funds through the vendors that manage those funds would be invested in the BCP infrastructure funds or other funds BCP owns?
Objection, Brian Haverly.
Mr. Haverly?
Madam Hearing Examiner, I believe the question was, does the BCP funds know this? Mr. Shell is not a witness for the BCP applicants or the funds. He is testifying on behalf of the joint applicants in his role as the New Mexico Gas Company president. To the extent that he knows something in that role, I'm fine with it. But asking what BCP may know or not know is, I think, inappropriate.
Does New Mexico Gas Company know whether New Mexico Gas Company retirement funds would be invested in the BCP infrastructure funds or other funds BCP owns?
No.
Thank
No,
you.
you don't know, or no?
Well,
the answer to the question is no.
The question, the answer is no. We currently
Okay.
aren't investing in private equity firms.
Thank
Okay.
you. Thank you for entertaining these questions, for your time. I appreciate it.
Thank you.
Very well. Any further questions for Mr. Gould?
No, ma'am, I thought we were moving on, so I got a little
Nope, not
premature.
yet. Yep,
Okay,
yep.
thank you.
Okay. No one else has questions? Oh, as has been indicated, Mr. Shell, from Hearing Examiner Schaefer, we appreciate your time being here. And hope that you have heard throughout the process from not only the public comment, but I think also from some of the witnesses, very very positive things about you and New Mexico Gas. So I hope you take that message with you.
Yes,
And with that, sir, you're excused.
thank you very much. Have a great day.
Thank you, Mr. Shell.
Same to you. At this juncture, I guess I want to find out what the next witness that gas company, the joint applicants proposed to offer.
So, Madam Hearing Examiner, the next witness that we would call would be Lisa Quilici. And we can have her join relatively quickly. She's going to be testifying remotely. So if it is your pleasure to take another witness, that's who we would call.
Well, and that's just why I wanted to know, because there's, according to my revised list, there's approximately 75 minutes. And I think we're going to have some procedural discussions. So what I have down here on the list is that the CCAE has 30 minutes, FEA has 15 minutes, and then staff has 20 minutes.
I'll also,
Is
Madam Hearing Examiner, have several questions for that witness.
okay, Hearing Examiner Schaefer. Then perhaps you and I should consider going ahead to our procedural matters.
I think so.
And calling it a week as far as the witness presentation and start early Monday morning. So we'll be thinking about that.
Madam Hearing Examiner, does that mean sorry, Madam Hearing Examiner, I apologize.
Well, is there anybody that objects to us releasing the witness until Monday and just talking about procedural matters for the last half hour? Which doesn't mean we have to talk about procedural matters for the next half hour. We could talk about them for the next 2 minutes, and then actually get to leave. Well, you all can leave. You can get off the Zoom at that point. I'm not seeing any objections for that. Yes, you can go ahead and release your witness.
Thank you, ma'am.
And so let's talk about that witness order. First, it would be Ms. Quilici and then Ms. Kelly, and then that would conclude the presentation of your witnesses, correct?
Yes, ma'am.
Very well. And then according to agreement, I believe it would then be, hold on a second. Are we going with NM area then?
Madam Hearing Examiner, this is Joseph Yar on behalf of NM area. I believe that was I think that was the understanding. However, there has been a development. Our witness, Mr. Walters, is unable to appear on Monday.
Okay.
His best day is Wednesday.
I was afraid you were going to say Tuesday. Okay. Then I see next Mr. Sandberg and Mr. George. Is that correct? Ms. Nanasi?
I was also hoping, and that's what I wanted to talk to you about, is if they could testify on Wednesday as well.
And are they in that order?
Sure.
Well, just asking. Okay. All right. And then it would be WRA, Mr. Kinney and Mr. Sabukel. Miss Beatles?
So I believe my pre-hearing memorandum refers to I'm sorry, I need to pull that up in order to make sure I give you reliable information.
Okay. Let's see. So I'm gonna need some witnesses for Monday.
She's fine.
So it's a
So
Hearing Examiner Hurst, I'm in contact with staff right now to see if I can have staff fill in if that's preferred.
well, I kind of would like to get the interveners. What about CCAE's witnesses? Ms. Lynch, Mr. DeSalen?
I'm currently looking up the availability. We had communicated to our witnesses that most likely they'd be called on Wednesday or Thursday, and we were told on those days there's one limitation on Thursday. I think I emailed you about that. I would need to check with the witnesses whether they'd be available on Monday.
Okay, so basically everyone is checking to see if we can get witnesses on Monday. Well, there is not a significant amount of cross-examination planned for the CCAE witnesses. Uh,
Hearing Examiner Hurst, I do know they're on East Coast time, so if there's a possibility for Monday afternoon, I think we could potentially, make that work. I, again, just don't know because I haven't communicated with the experts.
well, it looks like to me. Looks like to me that we should probably get through gas companies' witnesses by lunch, if not before. Like I say, there's only 65 witnesses, although 65 minutes, although hearing examiner Schaefer has questions for Ms. Kalichi. And then there is a couple of hours for Ms. Kelly. So, like I say, I think, we should be fine through lunch Monday morning, but we are going to need witnesses for the afternoon.
Madam Hearing Examiner, this is
Yes,
Mary.
ma'am.
My witness just said that if he has a doctor's appointment in the morning and till noon, and so if he can start, he would be able to start at 1.
Okay, and that's Mr. Sanderson?
Sandberg.
Sandberg. Okay, so we could have. And again, that's right now, the proposed cross is just a little over an hour for him.
Should he be ready but then though? That's what I'm asking.
Yes, that would be great.
Okay.
Ha-
That's what we'll
Thank
do.
him. Okay. And any word from Mr. George?
He
And
can't,
he's only got a half hour.
yeah, he can't do Monday, but he
Okay.
can do Wednesday. And he can
Okay.
start right in the beginning if or near the beginning, whatever is happening at that time.
Okay.
Hearing examiner Hurst, if for whatever reason we can't fill in with other intervener witnesses, I have two staff witnesses that can be available for Monday afternoon.
And who would that be?
Darren
Mr. Freeman.
Zigich and Mark Tepler.
Okay, that might be pretty good then. If we could get, I mean, that's a lineup of 6. What do you think about that, hearing examiner Schaefer?
I think that's a good resolution. I think with those, we should definitely fill the day on Monday.
Madam Hearing Examiner?
Mr. Haverly. It's like,
Mr.
wait,
Domi.
who?
Mr. Domi, I'm sorry, Mr. Domi.
Oh, Mr. Domi.
Hey, Madam Hearing Examiner, you said 6 on Monday and I count 5. I'm just wondering if I lost somebody.
Oh, I no. I had Mr. George right underneath Mr. Sandberg, but I had a different day. You're right.
Quilici, Kelly, Sandberg, Zigich, and Tepler.
Yeah.
Okay, thank you.
Thank you. All right, and then Tuesday, all the attorneys will testify.
Madam Hearing Examiner, they've been doing that already.
I know. So then on Wednesday, we have that's when we're going to go back to Mr. Walters.
Yeah, I did that.
I guess it looks like right now, approximately 2.5 hours. And I think we could get I think Ms. Nanasi said Mr. George in the morning. Also, and then we'll go on, Miss Beatles, and have your witnesses ready on the afternoon
Of Wednesday?
on Wednesday? Yeah,
Yes.
okay. And then we can go back in normal order with the CCAE witnesses and potentially on Wednesday, continuing to Thursday morning, and then Mr. Etheridge, and then following with the staff lineup. to fill out uh um Thursday, and then we'll be done. Or continue on till Friday. No one smiled. Okay. All right. I'll go through it one more time. We have witnesses Caliche and Kelly for gas company beginning on Monday. And then we have in the afternoon, we have Mr. Sandberg, and then potentially Dr. Zigich and Mr. Tupler. Holiday on Tuesday, and any carryover. And then we're gonna have Mr. Walters, Mr. George, and then potentially Mr. Kenny and Mr. Sabuko. And then we'll follow with CCAE witnesses, FEA witness, and then staff. Does that sound like what was agreed upon? Okay, very well. Well, that's one thing. We've got the lineup then for next week. Okay, we have some other procedural matters. Bench requests. Bench request 3 were the new commitments. And now today we just had another new commitment. Bench request 3 has not been filed.
Your Honor, Rick Alvidrez, there is a good draft. We need Mr. Baudier's sign off on it, but he is now airborne back home. But we'll have it on Monday, and we will add to that the bench, if you don't mind, folding in the bench request today with regard to the CAM.
Yes, that would be great. That was my next question. Okay. Were we going to discuss the NEE exhibits?
Yes, please.
Okay, let's take that one next.
Great. So the first is the good news, which is that 3, 4, 6, and 10 are accepted by joint applicants.
Are the versions that are accepted in the Dropbox?
Yes, they are.
Your Honor, Rick Alvidrez, if I may.
Do you concur?
I do concur with the representation of Ms. Nanasi that the supplementations have been added, although she did circulate those, so I think we're okay. I would also add to narrow the issue that the BCP applicants will also not object to Exhibit 11 and Exhibit 12 as supplemented. So that narrows the scope of what the objectionable exhibits are.
Okay, Ms. Nanasi, remind me, were there more than 3, 4, 6, 10, 11, and 12
Yes.
that you offered?
Yes.
Okay,
So,
what else did you offer?
the other ones, my understanding is that they are acceptable to joint applicants in form, but not necessarily in content. So exhibit number 7 is accepted except for 1-56, New Energy Economy 1-56. And before we I'd like to talk about this sort of substantively. And then we have 5, 8, 9 are not agreed to. So all in 7 are acceptable, except for one interrogatory, which is 1-56, and then 5, 8, 9, they just object to. And
Okay.
there are a couple of issues.
Well,
and
let me stop you just 1 second. Have you put 3, 4, 6, 10, 11, 12 as, are they all supplemented?
No. 3, 4, and 6 are just as they were originally. And let me pull that up.
So that means 10, 11, and 12 aren't.
Well, I just have to verify.
Okay.
Give me 1 second. Okay. 10, 11, and 12 were all updated, and the word updated in all caps appears in the Dropbox. And also I
Okay.
sent it to everybody.
So the answer is yes, 10, 11, and 12 updated are in Dropbox.
Correct. And I also sent them to everybody individually. So not the originals, but the one that's called updated. I'm asking to move into the record.
Okay. Okay. So NEE exhibit 3. All right. NEE exhibit 3 was the representation from Bernhard Capital's website, correct?
Correct. Under the portfolio tab, yes.
Okay. Any objection to what's been identified as NEE exhibit 3, Bernhard Capital, .com, from the website under BCP tab. Hearing no objection, I'll admit. NEE exhibit 3. Okay, NEE exhibit 4.
Is also from the BCP website, and that's under the tab strategy.
Okay, any objection to what has been identified as NEE exhibit 4?
No objection.
Thank you, as identified. Hearing no objection, exhibit 4 is admitted. Okay, let's go back and go to 6. Exhibit 6, Ms. Nanasi, is from gas company's website, and it says about us.
Correct.
Okay. Any objection to what's been identified as NEE exhibit 6?
No, ma'am.
Representation from gas company's website. Hearing no objection, exhibit 6 is admitted. And NEE exhibit 10. Joint applicants' response to new energy economy's second set of interrogatories and requests for production. And 2-31, 32, 34, 47 are included in that exhibit. Any objection
Your Honor.
to any exhibit? Am I looking at the wrong one?
I believe so. We had agreement with Ms. Nanasi that 32 would be withdrawn.
Okay.
And that 31 would be updated. And
Correct.
that is true with the exhibit that's exhibit number 10 with the capital letters updated.
Okay. It's weird that they don't, you put to have them in modification order.
I did the exact same thing I did the very first time, and I don't know what happened.
When did you put them in?
Last night.
Okay. We go updated. Okay, any exhibit 10, 231, 234, 247. And that's it.
With supplemental 231 updated.
Okay, very well. With as described by Ms. Nanas. Any objection to the identified NEE exhibit 10?
No objection. Your Honor.
Hearing no objection, exhibit 10 will be admitted. NEE exhibit 11, which hopefully is going to be right near 10. Updated. Is joint applicants' response to New Energy Economy's 8th set of interrogatories and requests for production. 8.1, 8.2, 8.3, did I miss? Nope. 8.5.
Through 8.11.
Okay, I see 6.
With a supplement to
Through 11.
With a supplemental 8, with a supplement to New Energy Economy 8.2.
Very well. Any objection to what has been identified as NEE Exhibit 11?
No objection to the version as modified.
Very well. NEE Exhibit 11 is admitted. So we can go on to NEE Exhibit 12. Now this one was updated.
Yes. And it says the word updated in all caps as well.
It does. And that's joint applicant's response to the New Mexico Department of Justice first set of interrogatories and requests for production of documents. Is that right, Ms. Nasi?
Yes, ma'am.
1.1-3, 1-4, 1-18, 1-19, 1-20, 1-38. And that's it. Is that correct?
With supplemented and MDOJ 119.
Very well. Any objection to NEE Exhibit 12
No objection
as
is up.
described?
No objection is updated. Thank you.
Thank you. NEE Exhibit 12 is admitted. Okay, so those were the agreed upon exhibits, but we still have 4 others that were not agreed upon. Is that correct?
If I may, Your Honor, that is correct, but upon further consideration, the BC applicants will also not object to NEE Exhibit 7 is updated.
Okay,
Madam Hearing Examiner, Tom Domi,
Mr. Dummy.
regarding Exhibit 7, we don't have any objection to it, but 38, and I don't know about this, but what I do, 38 should be updated, and it's not updated in the version that I have received. There is a supplement to 38 that's not in the exhibit.
Okay, let's take a look at NEE Exhibit 7 is joint applicants' response to New Energy Economy's first set of interrogatories and requests for production of documents. And it includes.
It doesn't include that because I wasn't aware that there was an updated needed. So I know that the only ones that was updated was 110, 142, and 145. So
Okay.
I can, if everybody agrees, I will find out what that updated document is on 138, include it, and if Mr. Dome will make his
Okay.
is
All right. So
conditional on my updating it.
Well, let's just say pending.
Okay.
On 7. Pending update. Okay. And 5, 8, and 9 are not agreed to. Correct?
Correct.
Okay, let's take a look at 5. Did you make your objection yet to 2-5, Mr. Alvidrez or Mr. Dome?
Your Honor, are you able to hear? Are you able to hear me?
Yeah, I can hear you.
Oh, okay, very good. It's not showing up. I don't believe that we've had a chance to address it on the record. Any Exhibit 5 was actually not ever mentioned. It is some sort of article from some place about the Petra Nova carbon capture facility, and has no relevance to this case. It's also, of course, hearsay, and I just don't know what what the basis is, but we do object to it. It doesn't have, as I said, any relevance to the issues in this case.
Do you want to address that, Ms. Nanasi?
Yes. So basically, there are three substantive issues left, and one is Petronova. And basically, Mr. Baudier, in his resume that I asked him about, talked about he talked about his prowess as a startup, and that he went from a project of NRG to then running that, and that became the Petronova plant. And he talks about that it was a success in his resume, and I asked him about that. And then these answers on both his answers about Petronova in New Energy Economy Exhibit 8.
Well, we're only on 5.
I know, but it's the same issue. So if I could just argue it
okay.
together and then we could separate them out, I'm happy to do that. I did ask him, did he write these, give these answers, and were they true and accurate? And the first two questions on Exhibit 8 are about Petronova. And you'll see that in his revised rebuttal, he changed slightly, and then in his and also in when I asked him about it in cross-examination, he then said, well, it wouldn't have been economic without DOJ funding. So this was like a change. First he said it was successful and was touting it, and then the issue is that was his past, and this was a carbon capture plant that turned out to not to be successful, and that he sold it at a loss. And so the article in Exhibit 5 is written by a person who's been deemed an expert by this commission several times. And then the question and answers that he gave in New Energy Exhibit 8, the first two questions have to do with Petronova. And we believe it goes to just the fundamental issue of impeachment. And so both 5 and the first two questions in New Energy Economy Exhibit 8, that's what that has to do with, is his history with Petronova.
Your Honor, may I respond?
Yep, just let me take a note here.
There is, I don't want to mislead anybody, but there is one other question with a totally different issue on New Energy Economy Exhibit 8, but I thought we would deal with that separately.
Okay. So you want to, are you responding to 5 and 8 or just 8, Mr. Alvidrez?
Oh, okay, I'm sorry.
Well, I wasn't clear that 8 had been wasn't clear that we were talking about 8. I saw some connection back and forth.
Okay, but yeah,
let me address 5 if I can for now.
Okay, sure.
So again, here we've got an article back from October 5 of 2022. I'm not exactly sure where it's from, but in any case, Mr. Baudier, I must disagree with Ms. Nanassi's characterization. He said that the plant has resumed operations, which happened after 2022. He wasn't necessarily touting it as a success, but he also indicated that his involvement was only in the initial portion of the project, and it didn't extend until to the operation of it. There was precious little cross-examination of Mr. Baudier about this, or I would have objected much more. But here we have some article. It's similar to article that was attached to the George testimony that they're trying to get into evidence, to make a case. We can't, examine Miss Matei or Miss, I think it's Dr. Schlissel actually, and ask them about
Doctor who? I'm sorry.
Miss Matei, Mattei, or Dr. Schlissel, that's Schlissel, about this, or the fact that the plant has begun operations again and those types of things. So I think it's highly prejudicial and does violate our rights to confront witnesses with respect to this standalone article that NE is trying to get into evidence.
And then what about with regard to the interrogatory responses in NE8?
Certainly, it's the same issue. They were interrogatory responses, and you'll see we originally objected. We agreed for purposes of discovery to answer, provide some information about the project in a supplemental response, which is included. And these are dealt with in interrogatories 128 and 129. But again, this is really completely irrelevant. The Petronova is completely irrelevant to BCP. It wasn't done under BCP's auspices, or there's no allegation or evidence that BCP had any involvement in it. It's simply one of the projects that Energy did while Mr. Baudier was there, and actually headed up the project. It was an experimental project financed in large part by the DOJ to have a carbon capture project on a large scale. So there was never any guarantee that it was going to be a success. But it is, as I said, the evidence would be that it is operating. 8 also includes 1-34E, subsection E, which deals with campaign contributions by BCP, which you previously disallowed. And we object on the same grounds that it's not relevant, and it is also a violation of First Amendment rights. So those are our objections with respect to Exhibit 8. And also, Exhibit 8 was never, well, I'm sorry, it was discussed, but.
You want to respond to the objection, Ms. Nanasi, for NE8?
Yes. In terms of Petronova, Mr. Baudier, clearly, I mean, he was on the stand for nearly 2 days. He's the most important witness in the case. This is his background. He put it into evidence. It's in his resume. I asked him about it. He basically said that this was a huge success. And then we asked him about it, and he answered about what he knows about Petronova. I can further argue about, I disagree with the facts that Mr. Alvidre said, but basically it's changed. Their first response was, this was a huge success. And now it's, because it wasn't, it was a failure, and it closed after 3 years of operating, never met its carbon emissions targets, cost a fortune. I mean, there's all these other problems with it. And the other issue that has been raised a number of times is, whether there's going to be an increase in emissions. And anyway, I'm not going to go into that whole part. But
okay.
So that's why, and these are his answers and his past history, and completely relevant. And it's true. It has nothing to do with BCP, but it has to do with their chief witness.
Okay. What about 9? Or did you have something else with 8?
Yes.
Yeah, you didn't answer. You didn't
deal with the
you
other.
didn't talk about the campaign contribution issue that the article got stricken on.
Right. But this is not the article. This is his answers. sworn testimony about the BCP. Here's the issue. We think that there was at least influence, and maybe a lot of negative influence, about the Louisiana approvals of BCP and that they came through via political contributions. They certainly had an impact. That's our position.
Okay.
Because would a commission allow for the approval of a private equity firm that has no gas utility experience, owning a regulated gas utility experience, accept it? And then there's all these contributions that he acknowledged. This is his language, not an article. And so we think the commission should know about it. They can give it whatever weight they want. Does it have an effect on his credibility, on bias, impeachment? I think yes. That's for me to argue. I might be unsuccessful about it, or I might be successful, and there might be some red flags raised. And that's why I think it's relevant. That's why I think it's certainly relevant, and goes to the public interest question about the fitness and the character of the potential new owner.
Okay. And then what about 9?
So 9 is similar. 9 is Mr. Baudier's answer, and this is about BCP coming to the state, wanting to get approval, and essentially doing the same thing here. I know it's different in the sense that we don't have elected commissioners, but BCP has spent $20,000 a month. And what is it for? It is for political strategy, ongoing strategic communication advice, and at least meeting with the governor. And this was only as of April. And so, again, is it legal? Drinking alcohol is legal, but you don't want to have people drinking alcohol while they're, arguing in front of the commission. So it's legal, but does that make it right? That's a question. And I think it goes to the bias, and it goes to the, why does BCP have to go do this? And is that what they're going to be doing in the future? Those are questions. Do I think it matters to the public interest? I think it matters. How much? That's for you and the commission to determine. But those are the reasons why I believe that these documents are relevant, and they are the words of Mr. Baudier. And I asked him about them, and he said,
Thank you, Mr. Nasi. Thank you.
And
May I respond? We haven't
yes,
addressed.
sir.
I haven't addressed 9.
Right.
Interrogatory. Exhibit number 9 is a single interrogatory. It's 1-65, and it deals with Mr. Gabello's, the lobbyist, role. And you've already ruled that questions about lobbying are irrelevant to this case, and I'm not sure, but perhaps also protected by the First Amendment. You sustained my objection when Ms. Nanasi tried to get into this issue with Mr. Baudier on cross-examination. But again, we're hearing all these things. It's casting aspersions against BCP for doing legal things. And Ms. Nanasi conceded that with regard to the hiring of the lobbyist, Mr. Gabello, there was nothing out of the ordinary in a utility hiring a lobbyist. And it really is unfair to cast aspersions on entities, companies that are simply exercising their First Amendment rights, that are doing things that are completely legal. And again, I would submit that it's not the role of the commission to decide whether a given lobbyist is a good lobbyist or a bad lobbyist. The commission doesn't have jurisdiction over lobbying or lobbying expenses or any of those types of things, except to exclude them. And certainly these expenses, any expenses associated with Mr. Gabello are not going to be included for recovery in any sense. So, it is really just, saying disparaging things about BCP based upon, legal and protected activities, which I think are entirely improper and irrelevant.
Very well. I will take NEE exhibits 5, 8, and 9 under advisement while I check the record. Anything further with regard to exhibits, Ms. Nanasi?
No, thank you.
Okay. There was a question from Mr. Alvidrez about the version of Mr. George's testimony that you filed. Upon review, I think it would be helpful if you did redline the testimony to show where the changes have been made. Okay?
Yes, I will do that over the
Oh,
weekend.
looks like I have. Can I get through my list or do you all need to say something now?
Madam Hearing Examiner, get through your list. I'm just wanted to, I have 2 exhibits, so that's the only thing. I just didn't want to put that off till
Okay.
Monday.
And Madam Hearing Examiner, the recovering public lawyer in me would love to weigh in on whether money spent for political influence is relevant. But I suppose you want to hear only from NEE and the applicants.
Well, usually that's, I think, what we do, isn't it? Yeah. Okay, we got the schedule for next week. We have the lineup of specific order. We got through the new version of the testimony. We got through the exhibits. I only know of one other issue. Mr. Gould, what exhibits do you have?
Madam Hearing Examiner, I have the 2 reformatted exhibits. The first is been uploaded to the Dropbox as NM Area Exhibit number 45, which is the joint applicant's response to NM Area Interrogatory 6-2, which was formally put into the Dropbox as part of NM Area 8. And this was the whole issue of the startup costs or the transition costs to stand up the IT, Oracle IT, and discussed extensively with Mr. Tuminello. And we'd asked for that to be admitted. You'd requested us to reformat interrogatory 6-2 as its own separate exhibit.
Have the joint applicants had an opportunity to review the updated NM Area 45?
Your Honor, I'll let Ms. Hardy address this since she presented Mr. Tuminello.
Ms. Hardy.
Thank you. I wasn't aware that had been uploaded, so I haven't had a chance to review it. I did not object to the admission of interrogatory 6-2, but I haven't had a chance to review the new version.
Would you like to review it?
I think that I would, Madam Examiner.
Okay.
Just to make
Could
sure.
Madam
Ms. Hardy, you are very quiet.
Be bold, Miss Hardy, be bold.
Huh. I'll try to speak louder. Can you hear me?
Thank you.
Yes, okay.
Madam Hearing
gonna-
Examiner, if I could just cut it short so we could all go home. Why don't we do
Okay.
this Monday morning? Everybody can look at both of them. The second one, if I could identify it, was uploaded about 30, 40 minutes ago as Enum Area Exhibit number 46. And it is the Enum Area Interrogatory 4-3. It was the response of Ryan Shell with respect to the folks that came from Amira and Tico to work at New Mexico Gas Company.
Okay,
And
thank
we've
you.
attached Mr. Shell's affirmation. And then I'll complete my statements. We attached the Peter Tuminello affirmation to the exhibit number 45. And as neither one of these I think should be controversial, but why don't we do it Monday morning? And that way everybody has a chance to look at it and we'll go from there.
Okay, thank you, Mr. Gould.
Thank you.
All right, anybody have any other procedural matters? Like I say, we have one outstanding. I believe, Hearing Examiner Schaefer, you're, ready to, deal with our other outstanding issue.
Thank you, Madam Hearing Examiner. So this relates to the verbal request, the oral request that was made by NEE for a bench request. Hearing Examiner Hurst and I would like to express our view that bench requests originate from the commission or the presiding officer for information that the commission or the presiding officer feels is necessary for the record or the inquiry or the review of an application or a matter, and that parties are not able to rely on such mechanisms within the commission's procedures and operations. Hearing Examiner Hurst and I are cognizant of the principles that NEE raises with respect to desiring the things that it stated, but do not find any basis to grant a request for a bench request from a party. Also, Hearing Examiner Hurst and I have determined that the matter has already been settled. The motion that NEE made has been dealt with by Hearing Examiner Hurst and I. Hearing Examiner Hurst and I do not find that any new facts were elicited or came to light in the cross-examination to warrant a reconsideration of the underlying motion. And for those reasons, Hearing Examiner Hurst and I will not issue a bench request pursuant to NEE's application, oral application, or reconsider the motion that was already ruled on several weeks ago.
Thank you.
Thank you, Hearing Examiner Schaefer. Anything further, sir?
No, not for me. Thank you.
Thank you. Well, I believe that we have dealt with all of our outstanding issues except for those procedural issues who have been deferred and until the two that Mr. Gould just indicated, and then also the additional update on the other NEE exhibit 7. Very well. Let me just say thank you all very much. I am pleased with the progress that we've made so far. I look forward to completing our case on time next week. And I thank you, Mr. Lee, for sticking with us, and I hope you get some rest. I hope everyone gets some rest. And why am I seeing hands raised?
Madam Hearing Examiner,
Mr. Gould?
a quick question. There was a mention today of starting early on Monday. So I just wanted to make sure that we knew what times we're going to start.
Right. You needed to listen to the rest of the sentence, sir. I said early at 9.
Okay, sorry about that.
Okay, did I have another hand?
Yes, Madam Hearing Examiner, I would ask to be excused on the morning of next Thursday. I have another matter that
Okay.
is pending, and I understand
Okay.
that when I'm gone, then I waive my I waive anything that happens during that period, but I need to be in another hearing.
Very well. All I would say, Ms. Nanasi, is just to clarify for the record, basically what you would be waiving is any cross-examination and or which I don't think you have scheduled.
Right. I don't have
I don't th-
and I'm not allowed
that-
to anyway.
well, that, yeah, I don't think you have any
actually, yeah,
cross-examination.
okay.
Let me
Limited
talk.
time, please.
You don't have any cross-examination scheduled further in this case, correct?
Correct. That's what I was going to say.
So the only thing that you would be waiving is your opportunity to weigh in on any further procedural dates, scheduling for things like post-hearing writings.
Well, hopefully you won't be dealing with that till the end of the day, and I hope that my other hearing won't go the full day, but it will just be the morning.
But you understand what it is you're actually waiving?
Yes. Anything
Very
that's
well.
discussed.
Thank you.
Thank you.
And with that, we are recessed until 9 o'clock. I will open up the Zoom at 8:45. Thank you all very much and good evening.